ahead, Mr. Chairman.
We're underway. All right, thanks. I'd like to welcome everybody to the meeting of the Harwich Conservation Commission from May 5th, 2021. This meeting is being conducted via remote participation. And I'd like to start off by reading a notice pertaining to that from the governor's office. Pursuant to Governor Baker's March 12, 2020 order suspending certain provisions of the open meeting law, Mass General Law, Chapter 30A, Section 18, and the governor's March 15, 2020 order imposing strict limitation on the number of people that may gather in one place. This meeting of the Town of Harwich Conservation Commission on May 5th, 2021 at 6:30 p.m. will be conducted via remote participation. Specific information and the general guidelines for remote participation by members of the public and or parties with a right and or requirement to attend this meeting can be found on the Town of Harwich website at www.harwich-ma.gov. For this meeting, members of the public who wish to watch the meeting may do so by recording on demand on the Harwich Channel 18 website or on our Town of Harwich YouTube page. Well, thank you all for attending. I'd like to call the meeting to order. And the first item on our agenda is a notice of intent for 5 C Street, map 7, parcel D22. It's a proposal for a new dwelling. Do we have a representative here who'd like to speak to the project?
Yes, Mr. Chairman. For the record, my name is Brian Wall. I'm an attorney and I represent the applicants. May I proceed?
Yes, good evening. Thanks.
Thank you, Mr. Chairman, members of the commission. I'm here tonight on behalf of the owners of the property, which is the estate of Lois Jones, and also the family friend and hopeful builder, Walsh Brothers Building Company. With me tonight is John O'Reilly, a professional engineer that the commission's familiar with from J.M. O'Reilly Associates in Brewster. And also on the call tonight is Stan Humphreys, a coastal geologist with Environmental Consulting and Restoration in Plymouth. And I see that Mr. Walsh is on the line as well. Mr. Commissioner, members of the commission, this is the third hearing on this matter, so I will try to be brief in my presentation. During the last hearing, when the commission was discussing the request for variance, the commission requested updated information on the dune. So we reached out to Mr. Humphreys, who was involved in the original 2012 permitting effort. And Mr. Humphreys has reviewed his previous findings and evaluated the existing conditions on the property. And he has submitted a memorandum confirming that the conditions are substantially the same now as they were in 2012. There was also a comment, I believe it was from the abutters, not the commission, but the applicant had asserted during the first and second hearing that the property at issue is accruing substantially. And there was a comment that insufficient evidence had been put forth regarding that. The evidence that we had put forth was the 1925 land court plan and also the existing conditions plan, which showed that the property had accreted seaward approximately 120 plus feet or almost 10,000 square feet. So since Mr. Humphreys was asked to be re-involved in this matter, he also looked at that and he reviewed materials including the shoreline change mapping at CZM and Google Earth. And Mr. Humphreys' memorandum does confirm that from 1938 to 2014, the land accreted at approximately 1.6 feet per year. That has accelerated lately from 1970 to 2014. It is 2.7 feet per year. And over the last 5 years, it appears to be going at about 5.5 feet because it's grown 33 feet in the last 5 years. If you do the math with regard to Mr. Humphreys' numbers, it matches with what the applicant had said previously. The lot has grown approximately 122 or more feet in the last 100 years. Mr. Humphreys is available on the call and he can answer any questions or discuss any of his findings with the commission. In addition to submitting that memorandum that the commission had requested, we also submitted about 25 photos. That might seem like a lot for a matter, but I think that using an old adage, a photo is worth 1,000 words. I think if the commission looks at those photos, and I know that many of you, if not all of you, have been out to the site, it's important to understand the condition of the site. It's the only vacant lot left in the neighborhood. And if you've been out there lately, it's essentially become a dumping ground. The photos show that someone has disposed of a split rail fence there. There's a pallet that's been abandoned. There's trash bags, bones that dogs have eaten and left there. It also shows that the site where the house is located is very stable. It's vegetated and is very far from the ocean edge. Thus, as we talk about the variance, you'll see that we think that this project can be permitted without any environmental harm. That's the new material that we submitted. I would like to briefly just remind the commission and review the arguments that we've made. I won't go through them in the length that I did originally, but just to refresh the commission's memory, we're essentially making two arguments in this case. First argument is that we have an active superseding order of conditions that was issued back in 2015, but has been extended to December of 2021. That order of conditions approved a house on this property seaward of the current location. And as you know, that approval was predicated upon a dune delineation where the edge of the dune is about 100 feet seaward of where the roadway is. We contend that we have the legal right to rely upon that dune delineation, and we have designed a house that honors the 50-foot no disturb zone from that dune delineation. And as we've contended in much more detail than I'm saying now, we contend that the proposed house complies with Commission's regulations if that dune delineation is used. We are obviously well aware that there's some disagreement with this legal position. And so what we've done is we've argued in the alternative, meaning that we are preserving all of our rights to make this argument about the dune delineation. But we are also understanding where the commission might be going on this. And so we are asking in the alternative, without giving up our contention to the 2015 delineation, that the commission approve this project by granting a variance. And so we have submitted a variance request to the commission. And I'd like to focus a little bit more on that tonight because that was presented for the first time at the second hearing, the last time we were here. So your regulations at section 1.13 recognize that the strict application of your regulations might not always be appropriate. And you have provided yourself the authority to grant a variance from your regulations upon two different circumstances, and these are not conjunctive, they're disjunctive. It means that one or the other gives you the authority to act and grant it. First is if the applicant can show the commission by clear and convincing evidence that the proposed work will not adversely affect the environmental values protected by the bylaw. And the second is if it's necessary to avoid restricting the property so as to constitute an unconstitutional taking. And in making these determinations, the regulation specifically says that the commission may consider hardship, financial or otherwise, to the applicant. As I said a minute ago, there's one or the other. You don't need to show both, but we contend that the applicant in this case has in fact shown both, that a variance can be granted because we can show you by clear and convincing evidence there will not be environmental harm. And secondly, that if you don't grant the variance, there will be taking in this case. So very briefly, why do we say there are no adverse effects? For the following reasons. One, the photos that I mentioned, I think if you simply look at those and see the houses that exist on the street and see the vacant lot where the proposed house will go, it just takes a common sense eye to look at that to see that there won't be environmental harm. But beyond that, we're proposing a modest 2-bedroom dwelling with a vitrifying septic system, elevated on piles to allow the sand to move. As I mentioned earlier, the DEP approved a similar dwelling seaward in this proposed location, which indicates that as far as the DEP is concerned, it meets all of the performance standards applicable to coastal dunes and that it will not result in harm. The property, as I mentioned, is accreting, and there are dwellings to the left and right and all up and down the street that exist presently. And that demonstrates that a house can be here without any environmental harm. So we feel and we respectfully suggest to the commission that we meet the first of two possible avenues for a variance. But secondly, we also contend that not granting a variance in this case will result in an unconstitutional taking of property. So what is a taking? A taking occurs when the government regulates property so restrictively that it takes the owner's right or beneficial use of land away from them. And we respectfully contend in this case that if the commission denies this project by applying its regulations strictly, it will deny the Jones family all beneficial use of their land. This will have a very significant economic impact to the Jones family. You might recall at the last hearing, I noted that in 2007, the land was valued at $1.8 million. When the Jones family began this permanent project back in 2011, the property was valued at $1.3 million. When the commission denied the project in 2012, the town decreased the assessment to $24,000. So fast forwarding to the present day, and this is all part of the record, I submitted documentation to support all of these assertions that I'm making. Presently, the house next door at 3 C Street is valued at $3.9 million, and the house on the other side at 7 C Street is valued at $2.6 million. But the interesting thing is when you look at the land valuation, because the assessor distinguishes between land value and building value, the land value for lot 3 is $2,201,900. The same is true for the lot at 7 Street. It's $2,201,900. Presently, the Jones property is valued at $35,500. That is a reduction in value of $2,167,400. But I want to tell the commission, and this is apropos of your standard that allows the commission to look at hardship, financial or otherwise, to the applicant. This is not a case where there is a wealthy individual that has put this property under agreement for something like $1 million and hopes to build a house on there and then comes to the commission with a proposal. And if they're denied, they walk away and they go on to another property. This is very different. The Jones family has owned this property since 1958. I didn't mention this the last time, but my client's mother purchased the property in May of that year, 1958. She had just become a widow. Her husband was a naval aviator, and he was killed in the line of duty when he was landing his plane in Pensacola, Florida, when the pilot behind him came in too soon and landed on top of him on the runway. Mrs. Jones actually used the death benefit that was paid by the Navy to buy this land, have a place for her family to go. And it's been an asset in the family ever since. They have paid the taxes on this property for 63 years. This is a very significant asset to the heirs of Mrs. Jones. They're regular middle-class people. One is a government civil servant. She works for the Commonwealth of Massachusetts. The other is a contractor that goes out in a machine and works every day. This asset that is worth $2 million was something that they thought they could use for their retirement or pay for their kids' college education or for whatever other reason. The loss of this asset will have a significant environmental effect on this family. So I simply want to leave the commission off to say the following. The commission has very awesome power to regulate property in the town of Harwich. And every night when you meet or weekly, that power often results in property owners having to accept conditions that they didn't want. Property owners often have to downsize their house. Maybe it can't be as big as they thought it would be, or maybe they had to put the house in a different location. Very seldomly does the commission's authority result in a total taking away of the ability to use land. This is a very unique situation tonight, and it has an awesome, significant consequence to this family because rendering this property unbuildable will result in a $2 million loss to the Jones family. I would respectfully submit to you tonight that this variance provision that you included in your regulations is there for a reason, to provide a safety valve, kind of like, you remember the steam radiators had that valve that they could let steam off so that the radiator didn't explode. That's what you can use this variance provision for tonight. Grant the standard, allow the house to be built. It won't result in environmental harm. It can be built, and a tragedy can be avoided. That's my presentation, Mr. Chairman. We do have Mr. Riley available to answer any questions regarding the details of the plan, and he might have a few words he might want to say. And again, Mr. Humphreys, the personal geologist, is on the line, available to answer any questions the commission may have, as am I. Thank you.
Thank you, Mr. Wall. I think I'll start by asking Amy for a summary from her perspective, and then we'll get into questions after that.
Sure, Mr. Chairman, unless, if you don't mind, if Mr. O'Reilly did have any other comments in regards to the actual plan itself before I start.
Sure.
Thank you. I went over the project initially on the first meeting. You've heard from Ms. Wilson some feedback, and I'd be happy to answer any questions when we get to that point. I don't think the commission needs to see battling consultants at this point in time. So I'd be happy to answer any questions that you have on anything we've provided you. Thank you.
Thank you.
Okay, thank you very much. So it's the commission's responsibility to look at the existing conditions on the site and to determine whether or not the proposed project meets the performance standards set forward in the Act, our bylaw, and our regulations. I will not speak about the previous case that we have ongoing in Superior Court for this project. I'll just speak to what is being presented here tonight. I apologize that I was not here for the last meeting, but I have fully reviewed the file and of course visited the site many times. I've been here actually this was my first case. Back in 2011, it was one of my very first cases as your agent. So with that being said, I would agree, the dune on the site, in my professional opinion, is more extensive than the site plan shows, meaning that the dune extends farther landward than the site plan shows, putting potentially the home itself in actual wetland resource area. That being said, the way I would view it is that, sorry, I have to collect my thoughts here. That the commission, we can discuss that wetland delineation, but typically dunes are very mobile wetland resources. And a delineation that was validated in the past may not necessarily be true when you actually go out there in the fields and see what's out there, especially when it is a coastal dune. So my recommendation is that this is unfortunately not a correct delineation that you see on your site plan. And then that being said, the project, the applicants would have to show how this project does not have an impact to the actual resource if it is in the actual coastal dune itself. In regards to comment about a taking, I'm not going to touch on that too much because it's not really, in the purview necessarily of the Conservation Commission. If it gets to that, we will deal with that. But in this current application, not in your previous one, you claim that there is a potential taking here, but I do not see, and correct me if I'm wrong, but I do not see where you have demonstrated that there is no other use of value to the property in your current application. Going back to the performance standards, coastal dune is significant to storm damage prevention, flood control, and wildlife habitat. In my professional opinion, this project will impact the dune moving landward and laterally and will impact the vegetative cover of the dune. Another requirement of the Conservation Commission under the wetland regulations and bylaws to provide mitigation for the project. Where in this project, mitigation is not proposed. I think that is currently it for me currently, Mr. Chairman.
I have one quick question for you, Andy. Have we received a formal request for a variance? I'm not seeing that in my documents.
They requested it verbally. I don't know if it was in the original filing. I couldn't, I quickly breezed through everything again before the meeting. Mr. Attorney Wall, if you could get to where a written request for variances, that would be really helpful.
Yes, we have formally requested a variance. It's set forth in my letter that was submitted on March 30th. It was before the commission at the last hearing.
Okay, but your request for a variance was for work. What was the language for the request for variance, please? A request for variance from what section of our bylaw?
So the request for variance was to allow the project to proceed. So whatever variances are necessary. Obviously, it's from if the dune goes to the road, we need relief from the coastal dune and buffer zone regulations.
Okay. If there's an agreement that the dune goes farther than the plan suggests, then the plan would need potentially a revision if there's a consensus and agreement among the parties that the dune is more extensive. The site plan should reflect that, in my opinion.
So may I follow up on that? Because the last thing, I think we said this the last time, is no matter what the commission decides, there's probably going to be litigation. If it's denied, the applicant will appeal, and if it's allowed, I think the abutters, are very likely to appeal. So I'd rather not have this denied on an informational basis. And so we have prepared a site plan that shows a dune delineation based upon that 2015 superseding conditions. For Humphrey's letter essentially says that the dune goes to the road or nearly to the road. So I think we're all in agreement with the legal line, and I know that there's a disagreement about the quote unquote legal line versus where the dune actually is. Do we need to actually show that on the plan? Or can we all agree that that's the state of affairs?
Thank you. Mr. Chair, before the commission speaks, would it be appropriate if we ask our counsel to weigh in?
Absolutely. Amy, would you like to issue any comments now?
Sure. Thank you, Mr. Chairman. Amy Questle, KP Law, Town Council. It was my understanding from the last meeting that the wetland line would be shown on the plan correctly. So it doesn't appear that that's what we have. So we still have a plan showing an old wetland line, but we have Mr. Humphrey's letter showing the correct, or the letter indicating that the coastal dune, that the line goes much further landward. Furthermore, we don't necessarily have an updated variance request because we don't have that updated line shown on the plan. And so I'm not really sure how we can make heads or tails of this. So, I always look at these things that, in 20 years, somebody's going to come back and say, oh, I'd like a certificate of compliance or something. And we have to go back into the file. Well, we're not all going to remember all of this stuff. So we need to have everything in order. And what the commission is looking at. The decision also is going to be based on everything being in order. And so I think there's that. I'm not sure that the variance request is updated because the house is essentially in the resource area. The other thing too is that in my experience, a coastal dune is a very, and I don't want to minimize any resource area at all, but a coastal dune serves a significant function. For storm damage, erosion, all of those, all of these interests, and to say that putting a house on a coastal dune will not impact, the dune or the protection that dune supplies. I'd like to see some backup on that. I'm not really sure. I've absolutely never heard of that. I've never heard that you can place a house on a coastal dune and everything is still the same, and the houses behind the coastal dune are still protected the same way they were, prior to that. And then the only other thing is that, Attorney Wall went through described a lot about the applicants in this proceeding, I think that this property, it was inherited, but one of the applicants is the Walsh Brothers Building Company Incorporated. So I'm not really sure that, I don't think that was addressed, but that is an applicant in this. So it's not just two people, as he explained. It's my understanding that it's not just two people, as he explained, but it's actually one of them is a corporation.
Thank you, Amy. Well, let's move on to comments and questions from commissioners. And I would say feel free to ask questions to Mr. Humphreys or Mr. O'Reilly if you have such a question. And I'll just go as I see you folks. So I'll start with Ernie.
Okay, thank you. Just a couple of comments. Mr. Wall, you made a comment that looking at the adjacent houses would demonstrate that there's no environmental harm to putting a house on this lot. I'm not sure how you make that extension to it, because we don't know how, I personally don't know how long those houses have been there, but nonetheless, I think trying to make that extension is not appropriate from my perspective. You also, with respect to the taking, and I think Amy touched on this with respect to other use. I don't think that anybody has explored any other beneficial use of the land other than just putting a house on it and using that as a demonstrative for the value that could be obtained from this. The other thing that I have constantly struggled with since we've been participating in these discussions is the fact that you alluded to it tonight, that the current owners have owned this lot since the 1950s, and just now are looking to get permission to build on the lot. From my perspective, the taking is not by any regulatory or board decision or anything. From my perspective, your taking is done by Mother Nature in this case. You've had since the 50s to do something with this lot and have decided not to. And during that time, I think any reasonable person would assume that a coastal lot will change over time. So the buyer's decision not to take action on this for 70 years now, I think is to their detriment. And I'm not sure how they can claim now that it's a taking simply because the delineation of the dune has changed. So that's one thing that I really struggle with from my perspective. And I think it's inappropriate at this point to claim that because of their decision not to take action on this is somebody else's fault, essentially, as far as the taking. Then the last thing I would like to mention is on the site summary that we have that's been submitted to us, it shows the house and it also shows the septic system. And then within the 50-foot boundary, it shows a full-size conventional primary supplemental system and then the reserve area. Under no conditions would we ever allow the backup systems to be placed within the 50. And I would suggest to you that if you want to move forward with any sort of appeal on this, that you need to remove those delineations from the site summary, because I mean, I'm willing to take a vote on whether or not we would allow those to exist within the 50 at this point. And I don't see any circumstances under which we would do so. So that's something you would have to deal with the Board of Health. That's all that I have. Thank you.
Thanks, Ernie. All right, next up, Mark.
I have no remarks, thank you.
Okay, thanks, Mark. John.
Yeah, okay. I guess I have a few things to say. One is that at this point, it seems to me that everybody who's had a look at the site agrees that the 2009 delineation is wrong, that the whole site is in fact a dune. And so I don't see any point in trying to have it both ways at this point. It's pretty clear to me that the whole site is in fact a dune, and we should be proceeding on that basis, and any decisions that the Conservation Commission makes should be made on that basis and no other basis. I also would like to echo the point that both Ernie and Councillor Quessel made about your assertion, Mr. Wall, that the existence of the other houses next door somehow shows, proves, demonstrates that no environmental harm would be done by building another house there. I don't think there's any logic in that. And in fact, my default assumption would be, it may or may not be correct, but I'd be more inclined to believe that if those houses weren't there, there would be dune there. And so preventing dune from forming there seems like, in my mind, that's environmental harm. They're already there. They will stay there, but I don't see that as any kind of argument for allowing us to build on yet another bit of dune there. So I guess that's all I have to say at this point. Thank you.
Thanks, John. Let's see, Jim, you're up next.
I mainly agree with those comments. It appears the delineation is incorrect and that the entire site is in the dune resource area. And, I think the locating a new house there will have some obvious impacts. There's no mitigation proposed. So I don't personally see any compelling reason to ignore the various regulations and laws by issuing variances to allow it. So that's my thought.
Thanks, Jim. Stan.
I have no additional comments, Brad.
Okay, thank you. And myself, I really don't have too much to offer in addition. I just think that if you look at potential adverse impacts to performance standards for prevention of pollution, prevention of impact to wildlife habitat, and impact to the coastal dune, it's a very difficult case to make a variance for any reason. So the impacts to me would occur. And so this one is not as complex. It's a long story. It's a complicated story, but the impacts to me are obvious. So I guess at this point,
Mr. Chair, if I may, I'm sorry to interrupt. But I just did want to make sure that the board acknowledges the fact that Mr. Wall, in his April 27th filing, added the order of conditions for 11 Braddock Street. I reviewed those order of conditions, and it appears that it's completely different circumstances. I think the conservation administrator would agree that here, in that circumstance, there was a house already on the property. And so because this order of conditions was submitted to the commission, I think the commission does need to address the fact that the circumstances are just, they're simply not the same. And I don't think that that order of conditions, in my opinion, has any influence over the project at hand.
Thank you, Amy. That's a good point. I hope the record will reflect that point. Very different properties. All right, Mr. Wall, does your team want to rebut any of the comments or offer new information?
I'll say a few words, Mr. Chairman, and I think maybe Mr. Humphreys might as well. So the staff said, conservation agent said that we have not shown that there'd be no impact on the resource. Mr. Humphreys' memorandum incorporated his letter from 2012, and he's reaffirmed that, and he's gone through every interest that's protected and made a showing that there will not be environmental harm. As far as the comments that were said that the evidence regarding no other use or other value, my brief response to that is this is a single family residential neighborhood. The use that's allowed by the town under zoning is for single family use. And there's case law that says, and I've cited it, it's the Pauling versus Bruins case, that if you deprive the owner of that use, you denied him or her beneficial use of their property. Thirdly, as far as the value deprivation is concerned, because of the denial the commission issued in 2012, the town reduced the property from at the time 1.1, now essentially 2 million, down to 30,000. The law of taking, and I know this is not a court of law, I don't want to get too far afield into case law, but the law of taking does not require a showing that it be zero. It requires that there be a substantial or severe economic impact. And I think that we've shown this. I think I did the math in my letter, and we're at 98.5% reduction in value. The fact that the applicants are heirs is not relevant to the taking analysis. The Supreme Court of the United States has said, never said it's not a taking because it's an heir. In America, you can inherit property, and that's the way that our country works. I'd really like to focus on whether or not the commission has sufficient information to make its decision. Our contention again is that the legal line is shown on the plan, and Mr. Humphreys' materials are telling the commission that the dune extends to the road. Do we need to show that on the plan, or are we all on the same page that that is adequate information? Because, again, I don't want the denial to be on lack of information. I'd rather not ask for a continuance for that basis, but I will if necessary. And a follow-up to that question is Attorney Questle said that the variance needs to be updated. I don't really agree, but again, I put it to the commission. Tell me if you think that you do not have adequate information or whether you do have adequate information, because if we have adequate information, I'd like to continue proceeding. But if you feel that there's not and you tell me what it is, we'll ask for a continuance and we'll address it.
Thank you for that explanation.
And again, I urge if there are any technical questions regarding the dune, Mr. Humphreys is on the line and he's available to talk about it.
Mr. Chair, if I may.
Yes, please, Amy.
I think having a plan that shows a delineation one way and a written statement saying that a delineation is to the entire road is inconsistent and probably wouldn't benefit either parties in the event of litigation. And then as far as the variance, I would support Attorney Questle's request that the variance language needs to be clear and change.
Mr. Chairman, this is Stan Hunt from ECR. As I recall, back when I first looked at the property, I made notes to the effect that the existing dwellings didn't seem to be adversely affecting the stability of the dune. To the fact that one of the performance standards is that vegetation cannot be altered or destroyed in such a way that it would destabilize the dune. I think this plan on piles, preserving all the existing vegetation around it, perhaps even enhancing it, would not result in instability of the dune. The second matter concerns the location, proximity of the road. I think relative to landward movement of dunes, this is very restricted. In fact, I wouldn't be surprised if any overwash sand in the past flooding is the sand's removed and probably placed back on the lot by bulldozers. So it's a very site-specific concern that the commission should have relative to the performance standards. And I do think this is unique in those number of ways, given the existing land use. It'd be a much different case if none of those houses were there and this was a wide open dune field that could move landward. But I just don't, I see those circumstances needing to come into play.
Thank you for that. Well, Mr. Wall, it seems that, you know, the commission is looking.
Can I ask just one clarifying question, Mr. Humphries?
Sure.
You made a comment that the proposal will not impact the vegetation on the dune, but we've established that the dune goes to the road. The house will be duneward, seaward of the road. How do you build a house without impacting the vegetation negatively?
Saying that, I'm saying that what vegetation is removed by the project won't result in instability of that entire dune.
But that's not the requirement that you have to meet.
So I think there is that connection between removal of alteration of vegetation to destabilize the dune. I don't have the regulation immediately in front of me, but I don't think that there's a standard that not one blade of grass can be removed.
And the presence of the house on the dune will promote shading that would prevent any of the vegetation that's there currently from revegetating underneath the house as well.
I can't argue against that.
All right, thanks, Ernie. Any other comments or questions from members of the commission? How about members of the audience? Mr. Reed?
Mr. Chairman, thank you, members of the commission. I'm Attorney David Reed, I represent Mr. Charles Curtis, who resides at 6 C Street Extension, which is the house almost directly across the street from this lot. We've appeared before you in the past on this matter, and I would just note for the record that you have 2 pieces of correspondence from me, the most recent being on April 2nd, for purposes of your last hearing. And you also have at least 2 letters from A.M. Wilson Associates, Ms. Arlene Wilson, also on behalf of Mr. Curtis, the most recent being April 30th of this year, addressing specifically the most recent submittals by the applicant. We continue to maintain, as I think at least the majority of the members of the commission have come to realize, at least by tonight, that the original delineation of the dune is not correct and has not been for many years. And I continue to submit that you are entitled, if not obliged, to make a decision based upon the newest information and the correct information. And that is that the dune actually extends all the way under the place where this proposed house is to be built or would be built, and out essentially to the edge of the road. And I think your determination should be made, as Mr. Crabtree, I think, indicated, based upon that fact and not clouded by any prior submissions or prior determinations different from that. The suggestion that the applicant has an active order of conditions from Department of Environmental Protection now, I respectfully, while that is true in part, it really, I think, has no bearing on your consideration tonight, because that final order of conditions that was entered back in 2016 is for an entirely different project and based upon an entirely different delineation of the dune. And in fact, it itself is not complete. It's final from the DEP's perspective, but one of its specific conditions, specific condition number 13, was that its approval was dependent upon the applicant coming back before you and securing your approval under the town bylaw of that same plan, the 2016 plan. You have declined to do that. And to date, your decision declining that supplemental request back in 2016 has been upheld by the Superior Court. What's before you tonight is not that plan and not that project, but an entirely different and new project, which now, tonight at least, concedes that the facts are also different, the facts in terms of the resource areas that are affected by this project. This plan, this project, to the extent to my knowledge, has not been reviewed or approved by DEP. So while there is an outstanding order of conditions from the DEP, it's for a different project, a different location on the site, and under different circumstances. And it is not the equivalent of a step up for this particular project to give it any imprimatur from the state that this is or would be approved, because as far as we know, it hasn't even been reviewed by them. On the issue of the variance and the taking criteria, and the two have been overlapped in the presentation and in the arguments in favor of the request for a variance based upon the hardship to the Jones family. Well, we can all sympathize with the circumstances and the personal hardship that the late Mrs. Jones may have had. It did have. I respect Attorney Wall's characterization of those, but that's really not the basis for a variance. A variance is not supposed to be based on purely personal hardship or personal circumstances. It's supposed to be based upon the hardship that relates to the property and to the circumstance that the property presents, not to individual personal background circumstances that have nothing to do with the particular development that's before you tonight. It's also my recollection, and I'm sure Attorney Wall can correct me if I'm wrong, but I believe there's a memo in your file from Town Council in the earlier taking discussions that in fact the prior owner of this property also owned the house across the street, and that this lot was essentially the front yard and the beach access for that house and for its occupants. And the owners chose at an earlier date to sell the house and separate it from the beach property, from the lot that's now before you. And therefore they chose to capitalize on the increased value of that other lot and to isolate the beach lot from the house to which it was previously at least functionally attached. So I don't think there is the kind of hardship that is argued tonight, and I don't think the background circumstances will justify that hardship in terms of elevating it to a taking case. The taking criteria that the applicant has argued have fairly recently been reviewed, as you all know, in the case out of Falmouth, and the appeals court decided there was no taking. That just because there was an extremely strict application of the regulations to a particular site does not necessarily equate to a taking. There are other circumstances involved. And that's a case that the applicant has been trying to make for about 6 years now in the Superior Court, and is still pending in the Superior Court. And that's probably where it ought to be. We don't believe that the criteria for the variance have been met. I've heard no discussion tonight other than from the commission about any mitigation that's proposed, and your regulations are very specific about what mitigation is required for even the slightest variances. Now, this would be, in my humble opinion, and I defer to you on your own experience, but it would be an extreme variance to allow not just an encroachment toward a resource area, but the entire project being located completely within the actual resource area. I would urge you not to take that step and not to grant that variance, and therefore to deny this application. And I would, again, actually agree with Mr. Wall on one point. I would ask you to be clear on whatever decision you make, and not, unless absolutely necessary in your minds, make a decision based upon the absence of information, but rather on the information you have before you, and to make a substantive decision and be clear what you're deciding and why. And when you reach that end, I hope and trust that your decision will be to deny this application. Thank you, Mr. Chairman.
Thank you. Other comments from members of the audience? Ms. Wilson?
Thank you. Arlene Wilson, AM Wilson Associates, also representing the abutters together with Mr. Reed. And I'd just like to add two quick points relative to the delineation. This commission denied a project based on the delineation that shows on the current plan. That denial was more than 3 years ago. It was upheld by the court. I believe, therefore, that the delineation, at least as to the town bylaw, comes into you fresh. And regardless of whether you believe that there is some requirement under 13140 that may result in the need to look at the old delineation, under your bylaw, that doesn't hold. And you get to look at the real delineation, which even Mr. Humphreys agrees runs all the way to the street edge. It is possible for the commission to make separate decisions, one under 13140 and one under the bylaw. It is not usual for that to happen, but if you felt constrained, you could do that and require the project to be looked at under your bylaw with the true delineation that every consultant that has looked at this lot since 2011 has agreed to, that the dune runs to the street. When you do that, the other point I would like to make is that the septic system cannot comply with the requirements of local Board of Health regulations, and therefore doesn't comply with the prevention of pollution standard either under the Act or the bylaw. Under the Act, a design is required not just to meet Title V, but all of the requirements of more stringent local Board of Health regulation. The town regulations say that where there's less than 6 feet of dry soil between the groundwater and the surface, it's called an environmentally sensitive area. That's the case here. And in an environmentally sensitive area, the Board of Health regulations say there shall be no variance for new construction. This is new construction. So not only can't they meet the standard for pollution prevention, they can't meet the standard to get a septic system permit on this lot. I will I'll not take up any more of your time. Clearly, you know my position on this delineation and the fact that building a house in a dune can't help but alter the dune adversely. Thank you.
Thank you. So, Mr. Wall, we've gotten advice from our town council and conservation agent that we need 2 features that before we can go forward. So are you willing to consider a continuance to get that information to us?
I am, and I just want to confirm that the 2 pieces of information are show the delineation that Stan has articulated in his letter onto the plan and update the variance request. Are those the 2 pieces of information?
Correct.
Okay. So, Mr. Chairman, I don't want to let this go unrebutted to the next hearing. I just wanted to make 2 very quick points. Regarding Mr. Crabtree's questions to Mr. Humphreys about the standard, I have the CMR in front of me, and it says the performance standard is as follows. Any alteration of a coastal dune shall not have an adverse effect on the dune by disturbing the vegetative cover so as to destabilize the dune. And so I think Mr. Humphries correctly said that, not that we can't alter one blade of grass or one of those yucca plants, but we can destabilize the dune. The second comment is I just wanted to speak to what Mr. Reed said about the standard. The variance standard in your regulations is different than the zoning standard because it does allow you to look at the hardship to the applicant, whereas under zoning, you're not allowed to do that. It has to be based upon certain conditions or topography, as Mr. Reed said, but your language is different than the zoning. Having said that, Mr. Chairman, we will ask for a continuance to provide you that information. I did hear Amy say earlier that your next hearing is rather busy. I would submit to you that all we are going to do at the next hearing is provide this plan and an updated written variance. We don't really expect to make any further presentation. So if you would see fit, we'd ask for the next plan, the next meeting, but I would defer obviously to your discretion.
All right, thank you, Mr. Wall. Amy, what do you think? Can we tuck this one in on, what is it, May 19th?
I think we can. I wouldn't take any more after this, and I would just state that we will need any additional information by Wednesday of next week.
Okay. Before I
That
make a
next
motion.
meeting is May 19th.
May I ask you, Mr. Wall, are you looking for a decision at the next meeting?
I'm looking to at least close the next meeting to close. You have the right to decide after you close, or you can deliberate and issue up to 21 days later.
Yeah, I'm not confident that we can entertain the information he's going to provide to us and discuss it and come to any sort of decision in any short period of time at the next meeting. Let's put it that way.
So I'm not sure I'm on the same page as you, Mr. Crabtree. Are you suggesting we not ask for the 19th, that we ask for a longer continuance?
That would be my suggestion. Amy, do you feel we can squeeze this in with that consideration?
The only reason well, I don't think it'll be as long as tonight's discussion or previous nights. I'm not entirely sure that the next meeting in June is going to be all that much lighter. I mean, it looks like it right now, but we haven't had a filing deadline for it. So that's why I think it really is up to the purview of the commission. Next meeting is looking heavy, but it's not saying that the meeting after is going to look any lighter, because we all know we've been having really heavy agendas lately.
I defer to the commission on this because, again, Mr. Reed and I at least agree on one area, that we want the decision to be based on adequate information and sufficient deliberation.
Yeah, Ernie, I would suggest that, we have heard this several times and some of us have heard this previously. So I think with this new information in our packet, I would encourage all commissioners to review the entire package and try to come up to speed on it. So I'm not too concerned about us taking an hour to review this at the next meeting. But it does require some upfront time and effort to review things. So, and we'll see. It also depends on what we receive for information as well. So with that, any final comments from anybody on this?
Can I just make something really clear, Mr. Chairman?
Sure.
We're going to be looking for an updated plan that shows that the site is a dune.
Yes, in a detailed statement on the variance request.
Thank you.
Understood.
Okay, well then I move that we continue the hearing for 5 C Street, map 7, parcel D22 on a new dwelling until May 19, 2021. Could I have a second, please?
Second.
All right, seconded by John. All those in favor by roll call, those in favor say aye, those opposed say nay, starting with Ernie.
Aye.
Mark. Aye. John.
Aye.
Jim.
Aye.
Stan.
Aye.
Myself. Myself, Brad Chase, aye. So the motion carries 6-0. Thank you all. We'll see you on May 19th.
Thank you very much, Chairman and members of the commission. Thank you.
Okay, next on the agenda, we have requests for determination of applicability. The first one is for 20 Bishop Lane, map 40, parcel N5. It's a request for pool deck and portion of a walkway. Do we have a representative here tonight for this project?
Yes, sir. Robin Wilcox from Sweetser Engineering. We had talked to you about a month ago. I apologize. Between Amy, Mr. Coleman, and my office, we've all been keeping the medical profession in business. We did get a revised plan into Amy. I don't think she to look at it. I hate to suggest continuing. It's fairly straightforward because your agendas are so long these days. But it's my fault I didn't get it into Amy in ample time.
I actually did have a chance to look at it. So it's up to you, Mr. Chairman. I did have a chance to look at the mitigation plan, and it was given to you in your Dropbox, even though it was today. I'd hate to prolong another case if we don't need to tonight.
Okay. What are your recommendations on this, Amy?
Mr. Wilcox, do you have anything further you wanted to add before I give my review?
We did call for a notching of the deck for the, there are 2 oak trees that are in the way of the construction, one of which is fairly substantial, and we propose notching around the tree so the deck is the same size, but we will be leaving one tree, and the other tree is, we had mentioned at the previous hearing, it's in very poor condition. It needs to come down.
Okay. Thank you very much for that. And I did have a chance to visit the site. And so with the revised mitigation planting plan, which puts more, I would say, appropriate plantings to the site, really at the back edge of the site, closest to the wetland. And it's a substantial number of plantings at least I think just greater than the 2-to-1 ratio that is required. My recommendation for their pool deck and portion of the walkway would be for approval, provided that the mitigation planting happen within the same or next growing season as the construction work, that they maintain that area because there is a substantial amount of invasives in the green space, which is owned by the neighborhood behind it. And I would hate to see those mitigation plants get overrun by things. And also with the condition, I think of, or I think what would be a big positive is the agreement for no fertilizers or chemical application within the 100-foot buffer zone on the property. So with that, with the current planting plan and those conditions, I would recommend approval of the project with a negative number 3.
All right, thank you, Amy. All right, let's look for comments and questions from commissioners. I'll start with Ernie.
No comments.
Mark.
Abstain?
John.
Yeah, no comments.
Jim.
No comments.
And Stan.
No comment, Brewer.
All right. Any comments from members of the audience? All right, hearing none, I'd like to ask for a motion from one of the commissioners at this point.
I'll make a motion to approve the pool deck and walkway for 20 Bishop Lane with a -3, with the mitigation plan as approved by Amy and the condition of no fertilizers or chemicals be applied within the 100-foot buffer.
All right, thanks, Stan. Can we have a second, please?
I'll second.
All right, seconded by John. All those in favor say aye. Those opposed say nay by roll call, starting with Ernie.
Aye.
Mark.
Abstain.
John.
Aye.
Jim.
Aye.
Stan.
Aye.
Myself, Brad Chase, aye. So the motion carries 7-0-1. Excuse me, 5-0-1. Still
Thank you.
doing the math.
This evening.
Really? All right, thank you. All right, too early in the evening to be screwing up on math. Okay, next we have a request for determination of applicability for 0 Mashpa Road, map 103, parcel V3-8. It's a dock addition on Long Pond. Do we have a representative here tonight for this?
Me, I am.
Hi.
Hi, Mr. Chairman.
Hello.
Hi, can you hear me?
Yes, fine. If you want to briefly summarize your project.
Yes, thank you for having me, everybody. I'm Katie Tortorello. In a nutshell, we have a permitted dock on Long Pond, and we would like to extend the dock by 8 feet, one dock section, to make it go from 72 feet to 80 feet as permitted by the town. This is a shared dock. There's 6 families that share it. And in recent years, the water level on Long Pond has been getting lower and lower and lower. And we have been concerned about boats docked at the dock. They've been, we've had damage to motors and even hulls from the boats hitting the bottom. It's a very gradually sloped shore. We're on the south shore of the pond. I guess all of Harwich is on the south shore. And you have to go out 35, 40 feet before you're in about 3 feet of water, which is kind of the minimum for the boats. And then it stays 3 to 4 feet from there on. So as a group, we thought that if we could add one section of dock, give us 8 more feet of 3-foot depth, then our boats would be safe at the dock. I have supplied a lot of pictures and information. I'm not sure I need to go through all of it at this point. I'm happy to answer questions, but as I said, in a nutshell, we just want to add one section of dock.
All right, thank you. Fairly straightforward. Amy, do you have any summary comments for us?
Sure. They did get permission from the Waterways Committee, Harbor Master, and Natural Resource Officer for this extension. I'll just make it known that the person who originally applied for this dock in 2002 didn't go for the Chapter 91 license, and Katie is aware that, you know, that's a part after this with the state permitting. And if you have any further questions about that, though I'm not an expert, I can point you in the right direction. They are asking to extend an additional 8 feet, so that would put it at our maximum length of 80 feet. However, though this is a large dock, it, I think, is an example of what we've asked people to do in the past, and people have been reluctant to do, which is have a shared use. Many families use this one dock, and I do think in this instance, you know, adding an additional 8 feet to protect the bottom better while still letting them, you know, use this is a reasonable request. So I would recommend approval of the RDA with a -2 determination because it's actually in the resource area, and just the condition that the dock be stored on the existing decking there or up top of the slope at somebody's, you know, on an existing disturbed area. I noticed your access way down to the pond is also fairly clear and open and really devoid of a lot of, you know, native vegetation other than native grasses. So that might be an additional option should you need the space to do so. So with that condition, I would recommend approval of their request to add a section.
Thanks, Amy. All right, let's go through questions and comments from the commissioners. We'll start with Ernie.
I have no comments. I appreciate the thoroughness of the application you submitted, and that was very self-explanatory. Thank you.
All right, Mark.
No comments. So, all very well.
John.
No comments.
Jim.
No comment.
And Stan?
No comment, Brad.
All right, I'd just like to echo Amy's thought that we do appreciate seeing the shared docks. It is a way to reduce resource impacts. So thank you for that. And I'll ask for a motion, please. First, let me ask any comments from members of the audience. All right, seeing none, would one of the commissioners like to make a motion?
I'll make a motion to approve the RDA for 0 Mashpar Road for the dock addition on Long Pond with a -2 determination and with the provision that the dock be stored on the upward landward on the top of the slope in a disturbed area.
Let's have a second, please.
I have a question. I'm sorry. Am I allowed to say this?
Yeah, that's fine.
There's a deck, as Amy mentioned, down at the shore, which was designed to store the dock. So we don't have to go up the stairs. And that is where we store the dock, not on the land, but on the deck during the winter.
We'll ask Stan to modify his motion to include that decking. Okay. I think you skipped that. I guess Amy gave us 2 options. And so let's just include the decking as well as uplands an option always.
Okay, I'll amend that to my motion to include the storage option on the existing deck.
All right, thanks. Could I have a second, please?
I'll second.
All right, seconded by John. All those in favor say aye. Those opposed say nay. With roll call, starting with Ernie.
Aye.
Mark.
Aye.
John.
Aye.
Jim.
Aye.
Stan.
Aye.
Myself, Brad Chase, aye. So the motion carries 6-0. All right, thank you very much.
Thank you very much. Good night, everybody.
All right, have a good evening.
You too.
Okay, next on the agenda, we have a request for determination of applicability for 18 Bob White Lane, map 17, parcel G4. It's a septic upgrade. Do we have a representative here for this?
Lynn Hamlin, representing the applicant. Thank you. Can you hear me?
Yep, good evening.
Good. This is a simple upgrade of an existing septic system. The property is located within land subject to coastal storm flowage in the buffer zone to a coastal bank and BVW, which you can see on the plan, wraps around the property. It failed a septic inspection. They're going to sell the property due to an inadequate separation from the bottom of the system to groundwater. So the new system is in maximum feasible compliance with both Title V and Town of Harwich health regulations. It achieves the 5-foot vertical separation from adjusted groundwater by having the soil absorption system constructed within the pressure treated tie, so it elevates. It's an elevated system that uses a pump. The existing system will be pumped and filled with sand and abandoned. We show a work limit line around the property that will be installed prior to any work being done, and we're proposing that the vegetation that's disturbed be replaced in kind. And I will stop there and see if you have any questions.
All right, thank you. Amy, any summary comments on this one?
Keep it brief. What they've designed is the maximum feasible compliance, considering this lot is well within the flood zone and really all within the 50-foot buffer to the marsh there. So I would recommend approval with a -2 and 3 determination with the condition of no, fertilizers and chemicals.
Okay. All right. Comments from members of the commission, starting with Ernie.
No comments.
Mark.
No comments. Thank you.
John.
No comments.
Jim.
No comment.
Stan.
No comment.
All right. I just have a general question. I haven't been out there in a little while. What is the status of the lawn now? Is it a planted lawn?
No, it's just a Cape Cod, very Cape Cod. Sorry.
Yeah.
It's not a lawn.
Yeah, that's what it's always been. Okay. All right, good. Well, then I'll ask for a motion. First, Sorry, let me ask, is there any comments from members of the audience? All right, seeing none, could I have a motion, please?
I'll move to approve the RDA for 18 Bob White Lane, map 17, parcel G4 with a -2 and -3 determination, with the condition that no chemical applications, our standard language about no chemical applications on the lot.
All right, thank you. Could I have a second, please?
I'll second.
All right, seconded by Stan. All those in favor say aye. Those opposed say nay, starting with Ernie.
Aye.
John.
Aye.
Jim.
Aye.
Mark, I missed you, sorry.
Aye.
Stan.
Aye.
And myself, Brad Chase, aye. That motion carries 6-0. Thank you.
Thank you.
Okay, next, we have a request for determination of applicability for 99 Riverside Drive, map 4, parcel A3-A1. It's a proposal for a base scallop farm on the Herring River. We have a representative here for the project.
Hi, yes, this is Dan Ward.
Hi, how are you?
Good, how are you?
Doing well? Do you want to briefly summarize your project?
Would you like me to summarize it?
Yeah, just briefly summarize what you intend to do.
Yeah, so the idea is this is at 99 Riverside Drive on the Herring River in Harwich, and this is at a property that's owned by Jeff Lang, the other applicant, along with me. And the proposal is to grow bay scallops underneath the existing dock at his property at 99 Riverside Drive. I am a farmer. My name is Daniel Ward, and I live in Falmouth. And I've been farming oysters and bay scallops, as well as sugar kelp and other species for many years. And I met Jeff Lang, and he is very interested in growing bay scallops, and I met him 2 years ago. And so last year, what we did is we contacted Heinz Proft, the Director of Natural Resources in Harwich, and asked him what he thought about growing bay scallops on the river. And he said, it sounds interesting. I don't know if it's possible, but let's give it a shot. And so we worked with the Division of Marine Fisheries and the Army Corps of Engineers to put out one lantern net, which is it's this vertical nylon net that can grow bay scallops. It's used for growing scallops of different kinds. And we hung one net underneath the existing dock in conjunction with Heinz, and it was very successful. The oysters, the scallops did very well. They grew very well. They all survived. We didn't really have any issues at all, aside from the tide being very strong there, which is great for growing shellfish. And so it went really well. And so we talked to Heinz about being able to expand the amount of bay scallops we're growing there under the existing dock. And because we're not seeking to expand any of the square footage of the area, Heinz thought that it would be something that the town could be in support of. So since then, we've gone in front of the Board of Selectmen to get preliminary approval. We've gone to the Division of Marine Fisheries, and they came out and did a biological survey and found and sent a letter to the Harwich Board of Selectmen stating that the amount of shellfish found was below the threshold of concern and that there was no eelgrass in the area. We went to the Waterways Commission committee in town, and they said that our application was not within their purview because it's under an existing dock. And so now we're going to Conservation Commission to, instead of going through an NOI, to go through an RDA because as you see in the proposal documents, nothing is ever touching the bottom. It's really, everything is suspended underneath an existing dock using existing attachment points to an existing wharf. And so at no point will anything having to do with this project in any way touch the bottom. Thank you.
All right, thank you. Amy, do you have summary comments for us?
My only additional comment really is that I did have a chance to email Mr. Lang because one of my questions was, what depth did you have at mean low water right adjacent to the boathouse there? And Mr. Lang, correct me if I'm wrong, because I'm not looking at your email, but by memory, I'm recalling you said at minimum 5 feet at mean low water, and then extending out much greater very quickly as you go out, so that there would be no structures, no bags or anything like that, actually touching the bottom.
And I can actually comment on that too, because I was there with Jeff and the Division of Marine Fisheries when we timed it perfectly for low tide so that we could do the survey. It's much more like 9 to 10 feet at low tide in that location, and we're going no more further down than 6 feet below the float. So even at ultimate low tide, there's still at least 4+ feet of water below the floats.
Okay, thank you. Maybe he meant to say there was below the lowest was going to be 4 to 5 feet. Okay, very good. Just out of curiosity, how many animals are you proposing to be able to house and grow out under there? Approximately.
That's a good question. It's really going to depend on stocking density, because any areas that I've ever grown before have much, much lower flow rates than the Herring River does. I mean, it's really amazingly good flow in there for growing. So it's nothing that I've ever worked with, to be honest with you. Normally my problem is not enough flow. And so I've worked with very similar systems where you incorporate pumps and things to increase the flow. This is one of those locations where we have maybe the most amount of flow that these animals can handle. So it's really going to depend on stocking density, but it should be able to be quite high there. I would hope more like 10 to 20 animals per square foot. And so if we can go down 6 rows, I mean, it would be quite a number of animals. I haven't done the math yet, but quite a bit.
Oh, that's really great. I mean, I think so my recommendation is a positive approval for this with a -3 determination, because it's in the resource area, or a -3 determination approving the project. And then, I mean, the ability to potentially clean up the water a little bit in the Herring River is a benefit too. Lots and lots of towns are using shellfish aquaculture to clean up their impaired water bodies, and Herring River has a TMDL, total maximum daily load allotted to it. So any little bit of help we can give it is a good thing. So I don't see this project as having any alternative or any adverse impacts. And for conservation, I would say I would have no further questions.
Thanks, Amy. All right, we'll go to questions and comments from the commissioners. Start with Ernie.
Yeah, this is a great project. I think this is fabulous, and I hope it works as well as expected. My one question is, they're proposing to leave the dock in between March through December 31st. And I think our bylaws require it to be out between April and October, or only be allowed in between April and October. So would this require a variance?
No, and we don't, oh, sorry, go ahead, Amy.
You go first.
You can remove that. We're not seeking to do that at this time. It's more than fine for our farming scenario and for the way that we work with the animals to go from April through the end of the fall. So that's perfectly fine to fit within the guidelines of the town of Harwich.
Okay, all right, fine. I mean, if you feel that the growing season would last into December, then I'm sure we could talk about granting variance to allow that.
I think perhaps if it's okay, maybe we can address that in the future if it becomes necessary. I don't think it will be, just based on the production cycle for scallops being a harvest in the fall and wanting to remove the gear and the floats for annual service anyways. I think it makes sense. It's just, it works within the cycle. But I would say if it'd be possible to address that in the future, if it's something that we do decide would benefit the farm, I think we'd appreciate it.
Okay. All right, good. And then the other question I had, so they're grown to approximately 1.5 to 1 inches, and then they'd be moved to the grow out site. Where would that be?
At this location, so the seed is produced in different areas. The seed can be produced at our hatchery that we're building in Bourne. The seed can be produced at some of my upwellers that are in Falmouth. And once it's pathology tested and approved at 1 inch size, that's when it's transferred to the site in Harwich.
Oh, I see. So this is the grow out site.
Yep.
Oh, okay.
Yeah, because you don't. That's the idea is that when you're doing seed. And the animals are very small. They need to be handled constantly, all the time, to be graded and up and cleaned and constantly maintained on a daily basis. The idea is once they get past a certain size, the maintenance is far less. They don't want to be touched. They want to be left alone. So effectively, we're front loading all of the maintenance into a site that's not at Jeff's house. And then once they get to a certain size, put them there and kind of leave them alone as long as possible until the fall.
Okay, great. Sounds fabulous. That's the only questions I had. Thanks.
All right, Mark.
Very interesting project. I hope it works out. I have no remarks. Thank you.
John.
Yeah, I just have one question, which is, can you say anything about how you might be scaling a project like this in the future or want to scale a project like this?
Well, I think it's really going to depend on how it's received in Harwich and the success of the financial success of being able to produce these and the biological success of being able to produce these animals and see where it goes from there. Because this is a very different farming style from oysters that you may be more familiar with, or clams for that matter, that requires constant labor and constant maintenance over a period of years to get a product to market. This is a much shorter growing season, right? So what we're doing is growing the animals off-site until they're around an inch or so, putting them in once, and effectively not touching them again until the fall, and then pulling them back out again. So because it's so less intrusive on the public and so less intrusive on whoever's property or whoever's dock this is, it kind of opens up other potential people that would be interested in this technique beyond your standard oyster farmer or shellfish farmer today that needs all kinds of equipment and time and employees and different things, where this approach is so different that it could scale to be other similar dock owners in the area. So if this is a method that, as Amy mentioned, is helping to clean the water, and this could be scaled in a way that can have a meaningful impact on a TMDL, I think it could be really powerful. It's just a matter of doing it in a way that fits in with the surroundings and fits in with what the stakeholders in the area want. So we're just saying we're doing this the proposal is to do this at Jeff's house, assess the biological and economic realities associated with it, and then we'll see where we go from there. And if there's other neighbors on the river that enjoy what they see and want to be part of it too, we can go down that path. But right now it's just Jeff's house, and we'll take it one step at a time.
Thank you.
Jim.
Yeah, it's an interesting project, and I hope it goes well, and look forward to hearing about it. That's all for me.
Okay, Stan.
Yeah, I just have one question. Can you just explain, it's more for my information, the dock, because you're saying the dock is there, but it needs to be reconstructed. And I'm just trying to understand what the difference is. And I'm looking at the pictures that were provided and everything and the explanation, but I just was trying to get a better understanding.
Yeah. So effectively, it's a dock that's there now that's just your standard boating dock, right? It's just made out of regular pressure treated wood, and it's got flotation underneath, and that's it, right? And so when we tried growing the scallops last time, what we did is hung them in this lantern net underneath and clipped them off to a rope. And that was fine, but because the flow is so high in this area, it caused the net to be tilted. As the tide would go in one direction or the other, the net would be tilted and it would deform. And so at one point, the tide was so strong that it actually ripped the lantern net off. I got my scuba stuff on, I dove in the water, I found it, we hooked it back up. So the flow there is so high that it's not ideal for using ropes or nets or different types of techniques like that. So what we want to do is actually be able to build supports underneath to make sure that we don't have that happen again. So the idea is the dock will be the same exact footprint, but we just need to add components underneath, and being able to add components underneath to hold the actual trays and shellfish themselves. It just will require moving the flotation around in different areas so that we can get access to the shellfish. So you could do it with the docks that are there. It's just, it'd be way more efficient to purpose build the actual equipment.
Okay. Like I said, I just want to understand the difference. I mean, it's in the same footprint, it's the same size, so just more information. Thank you.
It's really, I mean, same pressure treated wood too. It really comes down to the orientation of the floats more than anything else. The way the floats are now, they're not designed or oriented in a way that allows access underneath, because that's not what they were used for. So just being able to redesign them so that we can have hatches to access underneath causes us to need to move the flotation around a bit and change the sizes. But I mean, the orientation and the depth, the height of the flotation, but all the rest of the footprint maintains the same.
Okay, great. Thank you.
All right, I've got a quick question on your first season, your pilot season. Did you have market size scallops after 6 months?
No, it was, we put in 1-inch scallops in September, which is far too late for a 1-year crop, and took them out around Thanksgiving or so. We gave them to Heinz. Heinz came over and planted them in the Herring River. I don't know where they ended up, but that's where they went. So no, you have to get your seed much earlier in the season, which is the other half of this project. Is we're starting a base scallop hatchery in Bourne. And so we're in the permitting process for that right now. And the rationale behind that is that you need to get your seed much larger earlier in the season if you want a 1-season crop. So the seed that we put out in the pilot project, I received from a hatchery in July. So if you're having 1 millimeter seed in July, the biggest you're going to get that by the end of November is about 2 inches, which is fine. And it's good for some kind of niche markets, but not shuckable. You know, you can't actually shuck those. So to be able to get a 1-year shuckable product, you have to have the seed far earlier in the season. And most people and most hatcheries are focused on oysters and quahogs in our area. So we are getting the facilities to be able to do it ourselves. So it's really, it's a 2-step process. If we simply put in seed that we get in, say, June or July, they're really going to top out at about 2 inches in 1 year. And that's about what we saw. So they topped out at about 2 inches, you know, half dollar size, which isn't bad. And for propagation, it was excellent. Shucked, they're a little small.
Right. No, it sounds like you had very good survival. I think it's a really interesting concept to advance aquaculture in the Herring River and the region, so I'm very supportive. I'm not sure at this scale you're going to make a dent in our TMDL problems, but maybe we can scale it up and find other locations, other species. You know, certainly we support this activity in the Herring River. And any comments from members of the audience? All right, seeing none, would someone like to make a motion?
I'll move to approve the Bay Scallop Farm on the Herring River at 99 Riverside Drive, map 4, parcel A3A1 with a -3 determination.
The -3, Amy?
2.
Yep,
sorry.
In the
Sorry.
Right in the
I
resource
revised it.
area.
Yeah, okay.
Yep.
-2.
All right. You have a second, please?
Second. I'll second.
All right. Okay, seconded by Ernie. All those in favor say aye. Those opposed say nay, starting with Ernie.
Aye.
Mark?
Aye.
John?
Aye.
Jim?
Aye.
Stan?
Aye.
And myself, Brad Chase, aye. The motion carries. Good luck. And it'd be nice to hear back from you folks just to let us know how it goes.
Yeah, we will. We'll definitely be back. And yeah, we'll report back. Thank you very much.
All right, have a good night.
You too. Bye-bye.
Okay, next on the agenda, we have a request for termination of applicability for Lothrop Avenue, installation of 4 manholes within existing paved road surface. We have a representative here tonight.
Hi, good evening. Yep, Sarah French here, representing Eversource. Do you guys mind if I share my screen and put together a quick presentation?
No, that'd be good.
Let me know when you can see it.
I made you presenter. Oh, you're up.
There it is.
Okay, you can see it.
Mm-hmm.
Okay, great. Okay, so yes, for the record, Sarah French here. I'm with VHB. I'm here on behalf of Eversource Energy. This project is the Lothrop Ave manhole installation project. We have an RDA before you. A quick project overview. So the project consists of the installation of 4 new manholes within the existing paved travel surface of Lothrop Ave, and that's to access an existing electrical conduit that's beneath that paved surface. I don't know the exact date of when it was installed, but I think it was that conduit was maybe installed, maybe a year or 2 ago. So these manholes are just to access that conduit for any maintenance that needs to happen. And the electrical conduit is there to serve the abutters in that location. There is an exemption for work within the buffer zone under the Wetlands Protection Act. That's for installation of underground utilities within existing paved roadways, provided that all work is conducted within the roadway and that all trenches are closed at completion of each work day. Our project, however, is within land subject to coastal flooding. So that's obviously why we're here with this RDA for you guys. So our wetland resource areas in the location, there's the Herring River flows to the west. Is obviously that's our main contributing resource area, tidally influenced, as you know. So we have a lot of salt marsh within, on either side of the road. There is a little bit of BVW, but I think for the most part, it's salt marsh in the location of these manholes. And then, as I mentioned, land subject to coastal flooding. And then we also have a few areas of riverfront area. So our project impacts, 3 of the 4 manholes are located entirely within the land subject to coastal flooding and the 50 and 100 foot buffer zone to salt marsh. We have 1 manhole that's located within the 200 foot riverfront area. And then we also have 1 manhole that's within natural heritage priority habitat for rare species. I've kind of, these figures, I kind of tried to put everything on here, but you guys should have these figures in the RDA package that we submitted, so you can kind of see the full scope of the figures. So each manhole is approximately 6 by 10 by 8 feet diameter. So that will result in a total of approximately 1,440 square feet of temporary disturbance to land subject to coastal flooding and the 50 and 100 foot buffer zones. And then that 1 manhole that's within riverfront area, that will be 480 square feet of temporary disturbance. All work will occur, as I mentioned, within the previously disturbed existing paved travel surface of Lothrop Ave. The proposed work is not anticipated to impair any important functions of the resource areas or buffer zone, and there'll be no direct project-related impacts to salt marsh. I put together just a few pictures. These are also in the RDA package that we submitted. So starting up here, this is our southernmost approximate area of the manhole along Lothrop Ave, and then just moving north. This is then our northernmost. So these are just approximate locations of those manholes. So work description, obviously before any earth disturbing activities begin, we plan to install erosion and sediment controls, along the sides of that work area at the edge of the road where there are resource areas. They'll use an asphalt saw cutting blade to cut into the existing pavement to maintain clean edges. Sometimes they'll use water to keep the blade from overheating. An excavator or mini digger will then go in to remove the pavement and excavate existing fill from the hole. In this case, they'll probably use hand equipment because there will be that existing conduit. So they'll want to kind of be careful of that existing infrastructure. But they'll remove, the existing material, and then they'll place a bedding material to kind of create a stable base on either side of the conduit. And then they'll have a precast structure with an open bottom and slotted sides that will be placed over that existing conduit. Once the structure is in place, they'll use the temporary stockpiled material to backfill around it, and they'll use a vibratory compactor to compact the fill to ensure it doesn't settle. The work will likely take a few days, so they'll put a steel plate to cover the holes at the end of each workday. The manholes will sit flush with the existing paved roadway, so any disturbance beyond the manhole structures will then be repaved and sealed with an asphalt sealant. After all disturbed areas are stabilized, the erosion controls will be removed. And proper BMPs will be used. So erosion controls, as I mentioned, you guys can specify what you would prefer, but those would typically be either straw wattle, compost filter tube, or silt fence. No soil stockpiles will be left overnight. If for some reason we need to leave them overnight, they'll be rigged with erosion controls and covered. If there's any catch basins in the area, those will be protected with silt sacks. And then we'll have an environmental monitor that'll inspect the site weekly or as needed, depending on the duration of the project. So with that, we're hoping that the commission finds this project minor and issues a negative determination. So I will turn it back over to the chair if you guys have any questions.
All right, thank you.
Yeah.
Amy, do you have any summary comments for us on this?
Sure. Quick question. What is your proposed hopeful timing for this work, Sarah?
James Clancy's on the call. He's with Eversource. I don't know if there is a schedule yet for the work. James, are you on?
Are you guys able to hear me?
Yeah.
Yes.
Yeah. So thanks for having us, guys. So we don't have a set date for the project to start right now. We're in sort of internal pre-construction talks right now. So I think later this week is when we're going to have our first pre-construction meeting with the contractor. And I'm hoping at that meeting I can, sort of share your guys's any sort of conditions you guys have for that project so we can, get it going before the summer peak hits.
Okay, so before the summer peak. That's, I wasn't looking for an exact date, but season is good. So soon, it sounds like. So my assessment is that this project, given the parameters that you've discussed, installation of erosion control, I would recommend in this location, straw wattle should be absolutely fine for this. And that when, no stockpiling, unless, given the parameters that you've given, that if there is any disturbance to the sides of the road, that you revegetate with like vegetation, most likely they're a Cape Cod mix, or, if we get to that point, we can discuss that. And that I would recommend approval for this work with both a -2 and a -3 determination, because work is actually in the resource area as well as buffer zone. And I have no further comments. Thank you.
Thank you, Amy. All right, comments and questions from members of the commission, starting with Ernie.
Yeah, just one question. You mentioned that when you're cutting the asphalt with the saws, you'll use water to cool the blades. And how do you, that's, I think, the biggest source of pollutants that we could potentially get into the groundwater adjacent to the roadway. How do you plan to control that?
It's my understanding that it would just be, clean water. It would just be so that the blade doesn't overheat when they're using that. And I think there's certain types of, equipment that they can use to cut the asphalt. So you could certainly suggest that they don't use that type of equipment.
Amy, any comments to that?
Don't really have too many concerns or comments as long as it is, clean, fresh water. I don't see the huge addition of any erosion factors, if that's where you're at, what you're going for, Ernie.
No, I was more concerned about the contaminants from the roadway, the oil and the asphalt and everything else flowing out the water.
Yeah, I would, it's my understanding that it would be clean water. That was just in my research of how they cut into the existing asphalt. They typically use that method to keep the blades from overheating. But there will be, the erosion controls in place. And it's my understanding that it would just be clean water.
Yeah, so if you have silt areas around it, then it would be collected. The runoff.
Yeah, we can certainly have them circle the work area with erosion controls while they're performing that specific work, and we'll be out there. We'll have an environmental monitor out there so we can make sure that they do that.
Great. Okay. All right. Thank you.
Yeah.
All right, John.
Yeah, no questions. Thank you.
Mark?
Saw cutting asphalt's a common practice. The water volume there is really very small, Ernie. I wouldn't be particularly concerned about any contaminants spreading. The volume is really quite small. It's very common, and everything should be absorbed right there pretty readily.
Okay.
That's all I think.
All right. Thanks, Mark.
All right, let's see, Jim.
No comments.
Stan?
No comments.
All right, to myself, I have no further comments. Any comments from members of the audience? All right, seeing none, could we have a motion, please?
Yeah, I'll make a motion that we approve the notice of intent for the installation of manhole covers on Lothrop Avenue with a -2 and 3 determination.
Excuse me, I think it's an RDA, Ernie, right?
Yeah, he said a negative determination.
Yeah, I'm sorry. What did I say, notice of intent? My apologies. Our RDA with a -2 and 3 determination.
All right, could you have a second, please?
A second.
All right, seconded by Stan. All those in favor say aye, those opposed say nay, starting with Ernie.
Aye.
Mark?
Aye.
John?
Aye.
Jim?
Aye.
Stan?
Aye.
And myself, Brad Chase, aye. So the motion carries 6-0. Thank you very much.
Thank you, guys. Have a great evening.
All right, you too.
Thank you.
All right, we're moving on the agenda to the notice of intent. And first we have a notice of intent for 0 Snow Inn Road, map 15 parcel N8-B-0-R, proposal for a pier ramp, float and dredging. Amy, did they ask to withdraw this notice of intent?
Yes, Mr. Chairman, they've asked to withdraw without prejudice. We do need to vote to let them withdraw.
Okay. All right. I think any discussion, any comments from the applicants? All right, I see them attending tonight, or a couple of them. All right then, well, I move that we we allow a withdrawal without prejudice for the notice of intent for 0 Snowing Road, map 15, parcel N8-B-0-R. Can I have a second, please?
I'll second it.
All right, seconded by Stan. All those in favor say aye. Those opposed say nay, starting with Ernie.
Aye.
Mark.
Aye.
John.
Aye.
Jim.
Aye.
Stan.
Aye.
And myself, Brad Chase, aye. So the motion carries 6-0. Okay, next we have a notice of intent for 50 Martha's Lane, map 43, parcel B6-9. It's a proposal for a single-family dwelling with appurtenances.
Good
Ms.
evening.
Hamlin, yeah.
I'm Lynn Hamlin. I'm representing the applicant. Actually, Chris Childs from Patriots Builders should be here somewhere in Cyberland. This application is for the proposed construction of a single-family dwelling on a vacant lot in a 28-lot subdivision, on which most of the houses already have most of the lots already have existing houses. The resource area is a BVW. I submitted delineation field data forms. I don't think there's any issue with that. It's a constrained site in that it's in a zone 2. So the largest house you can put on this property is a 2-bedroom. And that will require a deed restriction recorded at the Barnstable Registry of Deeds. There's a catch basin in the front of the property from which the septic system has to be set back 25 feet. So that precludes the septic system being pushed closer to the street. What the engineer did do is use a crawl space in the first 10 feet of the foundation so that the house can be moved 10 feet closer to the street and further from the wetland resource area. So this project totally complies with state wetlands regulations. I think it complies largely with your town regulations in that the only portion of the construction within the buffer zone at all are the very corners of the garage and the dwelling and a portion of the elevated deck. The rest of the project, the sources of impact typically for resource areas, the septic system, the driveway, are all located outside of your jurisdiction. And the roof runoff from the house will be directed to dry wells, also located beyond the 100-foot buffer zone. The closest point of construction is the deck, which is still 80 feet away, and that's an elevated structure. From the resource area, the foundation is 92 feet away. And I know in your regulations that you acknowledge that the further the construction is from a resource area, the less likely the impacts to that resource area are to be. The project conforms to the 60-foot setback and then some of construction to the resource area. It adds and then some the additional 5 feet of undisturbed buffer strip. With the mitigation plan, you'll have 70 feet of undisturbed minimum setback from the wetland to the activity on the lot. We've proposed a mitigation plan which reinforces the work limit line with a staggered row of native shrubs and utilizes only native seed in any lawn area, which will be loosely maintained in the rear of the property of fescue, rye, and clover. There's minimum regrading on the property, so none of the drainage patterns will be altered. I write a pretty extensive narrative, so I don't want to read it to you and take up your evening. I go on record, as I do every time I have a project like this, as questioning the need for mitigation for impacts to the buffer zone alone. I mean, this project clearly will have no impacts to the resource area, and the impacts to the buffer zone are from 80 for the deck and 90 feet and beyond for the foundation. Notwithstanding that, we acknowledge that you look for mitigation for impacts to the buffer zone. And that's what we tried to accomplish with the staggered row of native shrubs. We have the work limit line where we've located it in order to allow for area to construct the residence. And then we're refilling the area, excuse me, with the native shrubs to fill back in once the construction is done. And I think you have a late evening, so I'm going to keep it short and try to answer your questions.
All right, thank you. Amy, do you have summary comments for us?
Sure. Lynn, this is relatively early. What are you talking about for us?
I know, I just got guess maybe just listening to him, it feels like it's long.
We appreciate that all the same.
Yes, absolutely. So I too will try to be as brief as possible. I agree with the wetland delineation that was done. I've been out to the property. The wetland was pretty much determined by vegetation type. This is a shallow pond with an extensive BVW around it. As Lynn stated, this is a vacant lot. I will not go over the setbacks as Lynn already did. This really does come down, I think, a lot to mitigation, which we all know is very difficult to do on a vacant lot that has 0 invasive plants on it. I know not all of the commission considers, removal of invasives and replanting of natives as mitigation, but I know it's in some cases we do. So the next possible thing is, and I think Lynn has covered it, is how can you minimize disturbance within the 100-foot buffer zone? And given the constraints on this lot, they also have additional constraints because of a catch basin right out in front of the street that prevents them from, even going closer to the street if they had wanted to. My other question was bringing in the work limit line essentially to the 97-foot contour. Chris Childs did email me back this afternoon and stated, for construction access, they really feel like they need the limit of work line where it is. Lynn is showing that landward of the limit of work line, almost to the proposed 97-foot contour, you are going to revegetate with native plantings that are suitable for that area. When I look at this lot, it's a nice native lot, but it is surrounded by other developed parcels. So had the house been proposed to be situated farther back, closer to the wetland, I would say that it would potentially have an impact to habitat and other interests of the act that are pertinent to a bordering vegetated wetland. It is somewhat in line, or pretty much in line, with the other houses on the street and kind of in the upper portion closer to the road, where I don't see it having a big adverse impact to any wildlife habitat. Wildlife habitat is closer to the actual, or in the BVW itself. So in this case, we're left with how to mitigate for some structure and some grading and clearing within the 100-foot buffer zone. The closest would be 64 feet is where the limit of work line is. And I will leave it up to the commission. We did go onto the site today, and people were curious about, just to state it out there for everybody, at town meeting this coming Saturday, we have a revision to our revolving account to allow for the inclusion of in lieu fees on what we consider mitigation constrained sites. And this potentially could be considered a mitigation constrained site, as a site that is natural and where mitigation traditionally would not be possible. So, however, that's not happening until Saturday, and we're not there yet. And if that change were to go into effect, because it's a financial matter, it wouldn't actually go into effect until July 1. But sites, I will just say sites such as this, I might consider in the future for such things. So I don't know if there's a way that we can discuss that tonight or not, but I know it did the question was asked on site today. So I'm not going to make a recommendation as of yet because I want to see where this conversation goes. I think I'll leave it up. I'll leave it there, Mr. Chairman.
All right, thanks, Amy. All right, comments from the commissioners. I'll start with Ernie.
Yeah. So Lynn, in light of the comments that Amy just made, and the frustration we've got with being able to charge in lieu of fees, especially on a lot that is as nice as this one is, and the absence of any invasive species and all that sort of thing on this lot. Can you tell me, would the applicants be willing to go with, I mean, essentially provide in lieu of fees for mitigation if and when this passes at town meeting?
I would have to know how you're going to calculate your mitigation fees. And I had asked Amy, I had given her different scenarios of ways the fee could be calculated. And the way it's written, I'm not quite sure what you're starting as your base number. So just for instance, on this property, if you use the area of disturbance versus the area of construction, which is a huge difference. So if you just straight use the area of disturbance and disregard what's being replanted, you come up with a $17,240 $17,240 mitigation fee. I think for construction, 80 feet away and 92 feet away, I think that's exorbitant. If you just, that is using 2 times. So if you're taking your mitigation factor, your 4 per square feet, and you're taking the mitigation that would be required, so your area of disturbance times 2, you come up with over $17,000. If you just use your area of disturbance, it's $8,620. Again, especially in consideration that your own regulation states clearly that the further away you get from a wetland, the less impact to the wetland, yet you're applying the same mitigation standard if I was 51 feet away or 99 feet away. So I have a little trouble with that. If you just use the area of construction, which is reasonable because this whole area is going to be replanted with native species, whether it be shrubs or ground cover, you still come up with a mitigation fee of $1,684. And that's using the 421 square feet of encroachment into the buffer zone, most of which is an elevated deck. I just have a hard time balancing the amount of mitigation against the impact, the possible impact that 421 square feet, considering it's still got a substantial buffer zone. And we, you know, you see the plans after I've tortured the applicants, you see the end result. You don't see the first revision. So we've talked the work limit line up. Everybody always goes straight across to try to increase your buffer zone. We fool around with the work limit line. Everybody reads the regulations and assumes you can put it right at 50, and we push it up and push it up and push it up. And then Chris informs me you need more than 2 feet to build, so we pushed it back a little. But then we revegetated that whole area. So the short, my answer, it's not short, it's longer than my presentation, is they would not be adverse to mitigation fee that was in concert with the impact. And I'm not sure, and Amy didn't get back to me, and I know she's busy and just getting back on her feet. And so I don't know how you're thinking about calculating that mitigation fee.
Well, you've mentioned 3 numbers, 17,000, 8620, and 1684. And you sort of suggested to me that all of those are high.
Well, the 1684 isn't high compared to the 17,000.
No.
If I subtract out the remitigate, if I subtract out, so if I take the area of disturbance and I subtract out just the shrub area, I come up with a number of 6,220. If I just multiply it for by the area of disturbance once you've planted back. That's a $6,000 number. So I'm giving you 4 numbers now.
Yeah, you are. There's no help at all.
But I don't know how you're going to calculate it because it doesn't seem to spell, there it is right there. It doesn't seem to spell it out. But I think, I mean, I hope you can.
Though. This is helpful. So this is helpful to have this conversation about whether or not it's clear or not. So for us, so.
Yeah, no, I don't think it's clear. But, and then I think you really need to look at, I think, and obviously you can disagree with me, that you have to look at setback, nature of construction. I just don't think it's fair to apply a blanket formula across the board, no matter how far away you are or what the structure is, or I think that there has to be some connection between impact and mitigation, whether it's in planting or in dollar amount.
It gets very nebulous when you start measuring distances and, you know, how much impact and all that sort of thing. It makes it very difficult for us, I think, not having a more definitive formula.
I understand. I mean, the problem, well, I think it's a problem, is that you extracted this mitigation fee from Barnstable. And Barnstable just seeks to put back 50-foot buffers where they don't exist. And then once they get their 50-foot buffer, then you're back to square one. You don't have to do any further mitigation. So what you've done is you take their mitigation, which is aggressive because they're trying to get back a 50-foot buffer, and you're applying it when work is 80 feet and further away from a wetland. So that I think is the rub for me. But I answered you very lengthily, lengthily, that even a word? But, you know, I think if you're going to insist that there's impact to be mitigated for, I think, yes, a client is willing to pay an in lieu fee.
Okay. I have no question in my mind that there is impact to be mitigated for, especially on this lot where it is so native and virgin and everything else, and absence of invasives and all. I mean, it's pristine, again, like some of the other ones that we've dealt with in the past. So that was my primary question. I mean, initially I was thinking of requesting things like the corner of the garage that's into the 100. I mean, they could obviously move that garage out of the 100 if we asked them to, I suspect. It might not be as aesthetic an appearance on the front of the house by moving it up, but it could be done, as opposed to moving the whole house up and moving the deck and all that kind of stuff. But I was more interested in your reaction to the in lieu of fee. And if that's agreeable, then I guess my reaction would be more to accept the proposal that they've presented to us and figure out what the fee would be at that point in time.
Excuse me, can I say something? This is Chris Childs from Patriot Builders.
Sure.
I just want to say that I don't think I think my client would want to understand more about that fee before they would agree that they would just pay it, you know, so sure. I'm not sure that they would just say tonight that they would agree to pay a fee that they have no idea what it's going to be.
I agree. I understand. That's completely reasonable, Chris. I can't argue that at all. So it sounds like it's incumbent on us to come up with a suggested fee for you to consider then. Is that right?
Correct.
Okay.
It would also, if I may, depend on the outcome of town meeting on Saturday, whether or not that's even going to be an option.
Yeah.
Because even if we come up with a number, if you know, this does not pass as an option at town meeting, or in certain circumstances, it's really for naught because we don't have a mechanism to accept it. So Saturday is critical.
Okay.
Or not necessarily your project, but in general for some of the projects the commission sees. So it's just an idea, another avenue to explore for mitigation when you have a site that's not conducive to mitigation.
So just to conclude my comments, I guess I would I would suggest that we defer a decision on this on two considerations. One, whether the town would approve it. Two, whether or not, and then it's incumbent on us to come up with a proposed fee if they do approve it. And if not, then we're back to the drawing board on it. And I would suggest, making changes to the proposal, and moving stuff out of the 100 and all that sort of a thing. So that's where I am on this. Okay, thank you.
Excuse me. Thanks, Ernie. Mark, any comments?
Yes, overall, I like the way this is laid out, and I match with what Lynn had to present regarding the in lieu fees. I'm not a tremendous supporter of that, just because there's so many holes in it, and I think the commission on the whole needs to be able to iron that out. To have that on the table as an option against this particular project, given the fact that it's before town meeting later in the week, to me this is premature. And for lack of a better way to say it, I don't want to see these people held hostage for something that hasn't taken place yet. But that's kind of how it appears to me, and I don't want that to happen. I'm much more in favor in every aspect of trying to bolster the no disturb area and build out from it. And I think that would be the avenue that I would pursue rather than making any radical changes to the design. The setbacks are pretty tight, and I think they've taken great pains to get everything where it is and have been very thoughtful in the design, and I would like to see the project go forward.
Thanks, Mark. John?
Yeah, so I have a sort of a different issue here, and maybe a different way to think about the possible mitigation. My observation, and I sort of take exception to Lynn's statement that there is no impact on the resource area, because I think that anytime you add potential nutrient load uphill from a wetland, there's going to be impact. And I didn't go down and look at the wetland. I looked at the site on Google Maps and looked at the satellite image, and my guess looking at that image was that it's already overloaded with nutrients and probably at high risk of algae blooms in the summer. And I don't think you can make any kind of case that algae blooms doesn't affect the resource area. They kill some of the species that live down there. There can be die-offs of frogs and other vertebrates down there. So my focus, instead of talking about how much area is being taken up, I would rather see the applicant address the septic loading by proposing an IA system there. And I would be inclined to accept that as potential mitigation.
Thanks, John. All right, Jim.
Yeah, I agree with that we should stay away from the in lieu fees until that's something that's actually approved and on the table as an option. It seems to kind of confuse the issue at the moment. I would agree with John that I would certainly be supportive of an IA system, or a system that would keep the nutrients from running downhill into the wetland. The other thing I'm looking at is to just make sure, I think that it's basically a reasonable proposal for that lot. It's the house is well set back and most of the buffer zone is preserved. So I'd be really interested in making sure that the buffer zone stays naturalized, and language involving either those plantings creating a living fence or a split rail fence, and that all the area between there and the resource be allowed to naturalize in perpetuity. with language like that, I would be in support of the project. That's my comment.
Thanks, Jim. Stan?
Yeah, I agree with John's comment. You know, we talk about these natural lots, and we've had other discussions about, you know, alternative mitigation, and we always wonder what that might be. Well, I think this would be a good possibility as to an alternative for mitigation in this case, as opposed to plantings. I mean, so this is something that I'd be in favor of. And just one other thing though, Lynn, and again, I don't want to get into the in lieu fees, but your comment about something being 80 feet versus 60 feet, we'd still be mitigating. I mean, any mitigation we do within that 50 to 100 foot buffer, we don't differentiate. It's within that area. So I would take exception to anything based on a distance, but again, I don't want to get into those discussions right now. But I would support what John's recommending.
All right, thanks, Dan. And for me, I think I'd agree with Mark and Jim that it is premature to try to impose some type of in lieu fee at this point. For me, I think there's a 421 square foot construction structures that would need to be mitigated for 2 to 1. And so things like the enhanced septic treatment, I think could be a potential mitigation, pulling structures back, and then maybe or augmenting the plantings as Jim suggested with the living fence. You know, we've seen lots like this where we allow construction and we see creeping encroachment occur towards the resource area. That's a common problem in the town of Harwich. So those are options. I think the planting list has some ornamentals, and so I guess I'm not in favor of those at that location. No?
No, I wait to address everybody's when you're done. Those are all natives. Oh, I'll approve native list.
Well, I guess the oak leaf hydrangea, that's an ornamental. Yeah, it's a native.
That particular hydrangea is a native, actually.
Yeah.
And it was arranged to be a living fence. Yeah. I just don't make them, they're in a fence, they're in a line. I just clump them so they don't look so artificial. They look a little more natural.
Mm-hmm. All right, well, if we go that direction where that becomes a mitigation for that square footage, I would like to see, some more native shrubs in there, wildlife habitat shrubs, as opposed to, some of these, which I do view as ornamentals. And so I guess those are just a few options in terms of how do we get to the mitigation. And I think you've heard a good number of options.
Yeah. If I could, real quick. Yeah. Sorry if I clouded the waters with talking about in lieu fees. I just wanted to bring up something that we did have a little bit of brought up when we did a site visit today. So sorry if I clouded things with that. And I do agree that we should wait till after town meeting to really start looking at that for projects. So I do agree with that. And if the commission wanted to see a couple of different species than what was proposed, hopefully the applicant, we could discuss that and swap out a couple species if that's what it came down to. Thank you.
I just want to address a couple of things if it's appropriate now. I pull the concept that impacts are lessened the further you get from the wetland from language from your own regulation, which I included in my narrative. So I'm not creating that. That's language from your own regulation. An activity undertaken 99 feet landward of an edge of a resource area will not have the same impact on that resource as the same activity undertaken 1 foot from the resource. Therefore, the closer the proposed activity to the resource, the greater the concern for adverse impact. And accordingly, the greater the level of scrutiny. So I think the commission, or a commission at one point, recognized further away you are, the less impact on the resource area. And just briefly, the septic system is 130 feet away from the wetland. It's 2-bedroom because of the Zone 2 designation. I'll have to talk to Chris about the use of the house because typically IA systems, especially if they're used seasonally, just don't work. And I forget the name of the study. When they did that study to revise Title V, there's 2 guys, 2 engineers, and I forget their name. But the state had a 50-foot setback, and they revisited whether effluent leaches horizontally. And part of that study was it does not leach horizontally, but because a long time ago, the state said 50, all the towns decided if 50 was good, 100 is better. But when they did that study, they reconfirmed that leachate does not travel very far horizontally. The important part is the vertical separation because you want to have enough of a vertical separation from the bottom of the leaching facility to adjusted groundwater. So the 2 ways that a SAS treats the pollutants is forming the biomat, which is done through use, appropriate use, which is a problem you get into when you over-design a system, and vertical height above groundwater. And those 2 aspects of the septic system are well in compliance. The other thing I just want to mention, because I have to go on record because I have to all the time, is that I think that when you apply the standard that you do to a vacant lot, it gets a little arbitrary because you could ostensibly have the exact same project on an exact same lot that the people weren't careful with and disturbed and destroyed, and that project could go forward because you could mitigate where you can't mitigate on a vacant lot. So I think it's an unfair standard that the lot that was kept pristine is at a disadvantage over the lot that was perhaps not taken care of, was cleared historically, or not treated very well. You'd almost be better off having a regulation that says if that's the way you want to go, there's no construction in the 100-foot buffer. That would almost be a cleaner way to do it, rather than what I think you're trying to do now. But if we have a lot to think about, we have to obviously talk to the Patriot Builders as the builder. We have to talk to the client. So I think it would be appropriate to ask for a continuance, and who knows, then maybe the thing will be approved and we can talk about it in Luffy.
Okay. We are pretty full on the 19th, so is it okay to move this to June?
It would be. I don't care. What I'm going to do for you is, Brad, I think I heard you say 421 times 2 is what you're looking for.
I think those are your numbers, I believe. That's what our bylaw.
And I believe that we pretty much achieved that with what I have. And then what I can do is look for a high value native plants, and I'll bring you that documentation. So if that's satisfactory to the board, then I won't need much time. I'm usually quick. I will take the hearing.
Yep. I would say, consider Jim's comments on the living fence, and I think you already have, but, I think that's important to slow down that potential encroachment. And if you could address, the enhanced septic treatment as well. It sounds like you feel like it's not viable, but maybe if you could just, think about that, discuss it, and come back. And then I think the third comment you heard was, can you pull something back and reduce that square footage you have to mitigate for? So those are the 3 things, if you could just consider. And how about the first meeting in June? Is that okay?
Chris, is that okay?
That's cool. Yes, that's okay.
What's that date, Amy?
That's June 2nd. You may have some comments from the audience, Mr. Chairman. I did have some people interested in this project, just to let you know.
Okay, sure.
I just have one other quick question regarding if the in lieu fee is approved on Saturday, would that then be on the table on the June 2nd meeting? Because it doesn't necessarily take effect until July, from what I understand. So I'm just asking if if that's going to be brought up again at the June meeting, or are we just going to discuss what we just talked about regarding some of the ways to mitigate and to, make some changes to the plan?
Yeah, it would be on the table because we would come July 1st. July 1st is when the commission would potentially be able to accept in lieu fees in order to improve our other wetland resources in lieu for doing this project here. So provided we get through town meeting with that and we have the approval for that, I don't see why it wouldn't be on the table potentially for discussion at the next meeting. We just couldn't implement it, meaning we can't accept any fees until
Right.
July,
Yeah.
until July 1.
I think the preference would be to move forward with some changes rather than do the fees, but I just wanted to know if that was going to be brought up again and then have to possibly delay even further if it is discussed.
I think if there are ways to minimize and accommodate the comments that the commission made tonight in other forms of mitigation, this is just me, that I would look for that first rather than going towards the end personally.
Excuse me, this is Sam. Yeah, I wanted to kind of concur with Amy. I always look at the in lieu fees as a kind of a last resort. So if we can accomplish something with the other things we've talked, that would be the better approach rather than going with in lieu fees. That's my opinion anyways.
Okay.
That sounds good. Any comments from members of the audience? All right, hearing none, we will have another hearing. So, excuse me, and I forgot the date is June 5th or 2nd?
2nd.
Okay, well, I move we continue the hearing for 50 Martha's Lane, map 43 parcel B6-9 until June 2nd, 2021.
I'll second that, Brad.
Seconded by Stan. All those in favor say aye. By roll call, starting with Ernie.
Aye.
Mark?
Aye.
John?
Aye.
Jim?
Aye.
Dan?
Aye.
Myself, Brad Chase, aye. The motion carries 6-0. Really appreciate the discussion. I think it was good to put a couple things on the table and prolonged it a little bit tonight, but I think it was very useful. So thank you.
Okay, thank you very much.
Thank you.
Have a good night.
Night. Okay, so we are on to orders of conditions. How you doing, Amy?
I'm good, Mr. Chair. Can we take something a little bit out of order? Because I know that I see somebody who's on here in case the commission has questions. Mr. Turner, I do see he's on here. So can we go a little bit out of order and do sort of compliance for the 2 Turner projects first?
Sure. Do you want to lead the discussion for the 2 separate orders?
Sure. So the first one is Darlene and Robert Turner for 18 Strandway, and it was SE 32-2334. This was for the proposed steps, dock, and dredging. So just as per my comments to you, that they have completed their requirement for shellfish mitigation. They have done their first year post-installation shellfish survey, which I did put in your Dropbox. I did go down to the site and just noted, and I have photos, and I haven't queued them up, but I was checking to see if there was any scour around. There was only 2 piles, and actually the dock spans the marsh, so there was no actual piles in the marsh. I was checking to see if there was any scour or negative impact that I could see to the marsh, and I did go at low tide. I did not note any degradation or scour. And the post-installation shellfish survey did come back still showing a good amount of shellfish in the area. And again, the marsh underneath the dock, which is quite high above the marsh, is coming, now it's spring, so the marsh is regrowing. And I noted that it is coming in just as well underneath the dock as in adjacent areas that don't have structures over it. So I would recommend a certificate of compliance for the dock with the ongoing monitoring conditions that they have in their orders of conditions.
All right, let's have some discussion. I guess I'll switch things around and start with Stan. Any comments, Stan?
Yeah, I think on my past experience of kayaking right under the dock there this past season, I had the same comments that Amy did. It looked very good. And I was very pleased with the no degradation around the marsh or the shellfish or anything. Looked real good to me.
All right, thanks, Stan. Jim?
I don't have any comments on this one.
Okay, John?
No comments.
Mark?
No comments.
Bernie?
No comments other than I'm really pleased to see that shellfish surveys are coming back very positive.
All right, thanks. I've got a couple questions. I've been down there quite a few times. And was this a site where there was shellfish plantings, where there was seeding occurred? That happened specifically at this site?
I'm not sure if I seeded it directly here. Mr. Turner, sorry, go ahead.
Yeah, well, I don't believe so. I have not seen anybody seeding any shellfish. I paid the whole mitigation fee to the town, and it's in their control where they put it, so I don't control that.
Right.
But I will tell you that I do see all the commercial shellfishers have been there all winter long, and when I've been around, they're out there every day shellfishing around my dock, on the river, and they're getting baskets and baskets full of shellfish for sure.
I've been out to your site probably 2-3 times in the past couple of weeks, and every time I'm out there, they're out there.
They're out there.
Yeah.
Mr. Chairman?
Yes.
This is Mark Burgess. So I recall during discussions that I believe my understanding was that Heinz didn't seed on the beach directly, that he broadcast the seed in the river and let it fall where it may.
Okay. Yeah, I'm curious. I don't think he would normally seed here. It's a little bit out of the way for recreational clambers on feet that would come down there. So, but there were more oysters, to my observation, than before the project into the intertidal zone. So can't really speak to cohogs, but did see quite a few oysters. Yeah, that's all I have. I think I did want to check on the width of the dock. I guess we actually did approve to have that bench, which exceeded the 4 feet. So that was part of the order. So that's something that the commission must have approved. So how do folks feel about waiting on the additional surveys? There's going to be, what, 2 more surveys conducted?
Yes, I've already contracted for the surveys to be done, and when they're done, they'll be turned into you.
Language, go ahead, sorry.
No, I can't do them until the summer of each, season. So, I mean, if I could do them today, I would, but the way it's written, I have to do it each summer, and I will do that.
Mm-hmm.
Yeah.
And Mr. Turner's language reads that, if the surveys come back in a way, or there is, if there's any noted degradation that could be attributed to the dock, that additional mitigation could be required. But I don't see it as a reason to hold up his certificate of compliance, was provided we put it as those as ongoing conditions.
Right. Do you expect the property would change hands? Is that part of this process?
No, I'm not selling. No.
Okay.
I just want to complete my order of business and be done with this project, so I don't have to continually, I want to get the order completed.
Yeah, you want to move on. Okay. All right. Well, I don't see any further comments on this piece. So if somebody would like to make a motion, we can approve one at a time.
Go ahead.
Well, I was just going to state that we haven't announced the other one yet, so I'll talk about the other one momentarily.
Yeah, I mean, we can do one at a time if you like. Or would you rather do them both at the same time in terms of the motion?
One at a time would be good, thanks.
Yeah, I think so. Go ahead, Stan.
Okay, I'll make a motion to recommend approval for the requested certificate of compliance for 18 Strandway for the proposed step stock and dredging with the ongoing monitoring condition.
Okay, can I have a second, please?
I'll second.
Seconded by John. All those in favor say aye. I'll start with Stan.
Aye.
Jim.
Aye.
Mark.
Aye.
John.
Aye.
Ernie.
Aye.
Myself, Brad Chase, aye. Motion carries 6-0. Okay, on to the next one.
Again, for Darlene and Robert Turner at 18 Strandway, it was SE 32-2344 to raise an existing dwelling accessory structure and hardscape, construct new dwelling accessory structure, driveway, pool, hardscape, grading, and landscaping, remove invasive plant species and restore the bank, and rebuild a stone revetment. So we looked at this site last year, and I think the commission wanted a little bit more time to just notice, you know, make sure the mitigation plantings were coming in well, and there was also questions about the lawn. So I went back a couple of times this spring, winter and spring, and the mitigation plantings I saw as early as the other day, and they look fantastic. I must say they're really coming in nice, and they're really robust plants. I looked at the lawn again, and the lawn does have some diversity coming into it in the way of different fescues as well as clovers, and I don't see any treatment going on up there. It is a little bit, you know, patchy, and it looks more like a Cape Cod lawn. So let's see. The only change from the approved site plan was a window well on the south side of the house. I find that this is, and the pool is in a slightly different shape, but the patio that contains it is in the shape that we permitted, so the footprint hasn't changed. So I find that the project is in substantial compliance, and that I recommend you issue a certificate of compliance with ongoing conditions regarding, you know, the no chemical application within our jurisdiction, which is the 200-foot riverfront area.
All right, thanks, Amy. For comments, start with Stan.
No comment.
Jim.
No comments.
John.
No comments.
Mark.
No comments.
Ernie.
I'm good. Thank you.
All right, and myself, I'm good too. I think similar to the shellfish surveys, if any issues pop up, these are ongoing conditions, and we can revisit them as we need to. So any additional comments from anybody, members of the audience? All right, I'm going to go ahead and move that we approve the certificate of compliance for 18 Strandway, SE 32-2344. Can I have a second, please?
I second it.
All right, seconded by Stan. All those in favor say aye, starting with Stan.
Aye.
Jim.
Aye.
John.
Aye.
Mark.
Aye.
Ernie.
Aye.
And myself, Brad Chase, aye. Okay, the motion carries 6-0. Thank you for your time.
Thank you so much. I greatly appreciate it.
Okay.
Thanks, have a good night.
Yeah, thanks, Amy.
Yep. All right, you want to go back to the top, Amy, to the order of conditions?
Yeah, I don't know who else. There's a Leanne McLaughlin on, and I see Lynn is still on. I don't know if they're here for anything in particular that's on our agenda, but I guess if they can speak up. Other than that, we'll just go back to order, our regular order.
Yeah, if they would like us to address one of these items right now, that'd be fine, but if not, we'll start at 2121 Heather Bay Road, map 108, parcel K2, vegetation management.
Yeah, I'm not seeing any comments from them, so let's just do that.
Okay.
So for that one, 2121 Head of the Bay, does anybody have any comments you'd like me to change or things you'd like me to change?
I'm good on that one.
I did have a comment. I gotta get the document up, but I think it was special condition number 8. There's something about the language that was thought needed a little repair. Hang on a sec.
I gotta go there too, so just give me 1 second as well.
Yeah, so starting with the third sentence in special condition 8.
Hang on 1 second. Not there quite yet. Feeling a little slow. Okay, I'm there.
So I'm sorry, it's a little nitpicky, but that sentence doesn't even have a subject. Shall include, and.
Okay, no, this report shall include, yeah.
It shall include completed work and work that is yet incomplete or something. I don't know.
Yeah, I'm sorry. I don't know why I didn't finish that.
Subsequent sentences have a similar problem. Well, photos to be included, no big deal, but shall be, I don't know. It just needs a little.
Yeah, I see that. I don't know why it's choppy like that. I will fix that. I know what you mean.
It's not a content problem.
No, I wonder if some periods were supposed to be commas. I don't know what happened there. I will fix special condition number 8.
That's all I have.
Anyone else had comments on that one? No, I'm going to move that we approve the order conditions for 2121 Heather Bay Road, map 108, parcel K2. Have a second?
I'll second.
Seconded by John. All those in favor say aye, starting with Stan.
Aye.
Jim?
Aye.
Mark?
Aye.
Ernie? You with us, Ernie? All right, I'm going to Brad Chase aye, so that's 5-0 approved. I'm not sure if Ernie's still with us. Next, we've got 4 Braddock Street, map 7, parcel F17, beach maintenance. If anyone has comments, go ahead and speak up.
No comments.
I've got no comments on this one. Any comments, anybody?
No, none for me.
All right. I hate to interrupt you, Stan. Looks like you're still editing. You good? Okay. All right, then I think hearing none, I'm going to go ahead and move that we approve the order of conditions for 4 Braddock Street, map 7, parcel F8 on beach maintenance. Could I have a second, please?
I'll second
All right, seconded by Stan. All those in favor say aye, starting with Stan.
it. Aye.
Jim?
Aye.
John?
Aye.
Mark?
Aye.
Ernie? And I think Ernie's, we lost him maybe. So myself, Brad Chase, aye. The motion carries 5-0. And now we have 41 Sequoia Road, map 101, parcel S5-2. This was for reconstruction of an elevated timber stairway, repair patio and wall, repair boathouse and shed, install a kayak rack, and replace the existing seasonal dock with a new seasonal dock. I don't know how this is possible, but I'm down in the basement. I can smell dinner upstairs. That usually doesn't happen. So something really good's cooking up there.
Something's really good cooking and you're really hungry. So
Yes.
we'll finish this up, we'll finish things up and we'll get you going.
That's how I'm thinking. Anyone have comments on this one?
No comments.
I think we're missing Carolyn tonight. She always finds something. All right, if everyone's good, I'm going to move that we approve the order of condition for 41 Sequoia Road, map 101, parcel S5-2. Have a second?
Second.
All right. All those in favor say aye. Starting with Stan.
Aye.
Jim?
Aye.
John?
Aye.
Mark?
Aye.
Ernie? I think we've still lost Ernie. And so myself, Brad Chase, aye. Motion carries 5-0. And so next we have 14 Hardin Lane, map 76, parcel A3. It's
Did we, excuse me, Mr. Chairman, did we miss 34 Red Pine Drive?
I was gonna go back. Yeah.
Sorry, yeah. All right, well, I guess I'll just complete this announcement. We'll come back to that. Thanks for that, John. This is a proposed construction of an addition and deck, installation of a temporary tight tank, and future sewer line, and installation of a gas line and plantings. Are these copies, is this one highlighted in yellow?
Yeah, it was highlighted in yellow because we forgot to put it on the first agenda, so we had to revise it. And when you revise an agenda, you got to put the revisions in yellow.
Okay.
So we're good. There's no other reason other than that.
No, I wondered. Couldn't remember if I had did that. You back, Ernie? I think we lost you for a minute, Ernie.
Where the hell's my volume now?
I don't think Ernie, can you hear us? No.
So he changed his venue too.
Yeah, he was starting to talk there for a minute.
You can't hear us, so.
Yeah, okay. All right. Well, anyone have comments on that order of condition for 14 Hardin Lane?
No comments. 14, wait a minute. 14 Hardin Lane?
Ernie, we've gone through a couple. I don't know if you can hear us or not, but I think we lost you for a few of these orders. So he must have heard us say 14 Hardin Lane.
No, so 14 Hardin wasn't in my site summary. It is on the agenda.
So, I see 34 Red Pine Drive here. Do I
We're
have,
gonna do that after.
where is 14 Hardin Lane? Am I looking
It's
at
not on my site. It's not on my site summary.
the site?
It's on the agenda.
I got it.
Do you want to come back to that one, John, if you haven't looked at it yet? It's in Dropbox.
Yeah, I don't, did I look at it? Wait a minute. No, I think I looked at it. I think I'm fine with that. I'm sorry.
Okay.
Yeah.
All right, any comments on 14 Hardin Lane? Everyone good? Ernie, I think we're still not hearing you. Can you hear us? Okay.
Yeah, I can hear you. I'm sorry, my computer just blew up on me.
We can hear you too.
Okay, good, thanks.
All right, good. So we're doing 14 Hardin, and we're gonna go back to 35 Red Pine Drive, and we've approved the others. So if you have any comments on 14 Hardin, we're about to move that.
No, I'm good.
Okay, well, I'm gonna move that we approve the order of conditions for 14 Hardin Lane, map 76, parcel A3. Can I have a second?
Second.
All right, seconded by John. All those in favor say aye. I'll start with Ernie.
Aye.
Stan.
Aye.
Jim.
Aye.
John.
Aye.
Mark.
Aye.
And myself, Brad Chase, aye. So that's 6-0. And the last order of conditions is for 34 Red Pine Drive, map 82, parcel X18. And this was a single family dwelling. So we'll review that one now. If anyone has comments, just go ahead and speak up. How you hanging in there, Amy? How's the what you had earlier? Is that gone by? The headache?
No, I'm in the middle of a cluster migraine that I'm on day 2 of what's usually a 3-day cluster. So it's not a debilitating one. I can still function. It's just not pleasant.
Oh boy. Well, I'm sorry. Well, we'll be done pretty soon.
Oh, you're good. I'm hanging in there. Bye.
9:30 was a bonus lately.
Yeah. I had no comments on this one, on Red Pine.
Yeah, I'm also.
No comment.
All right. I'm going to go ahead and move that we approve the order of condition for 34 Red Pine Drive, map 82, parcel X18.
Second.
Okay, thank you. Second by Ernie. All those in favor say aye. Starting with Ernie.
Aye.
Stan.
Aye.
Jim.
Aye.
John.
Aye.
Mark.
Aye.
And myself, Brad Chase, aye. Motion carries 6-0. All right, anybody have any new business or other business to bring up?
We have an extension permit request.
Oh, sorry about that. I missed it. All right, so there's an extension permit request for 3 Holtz Point Road, map 6, parcel A2-4. This is a dwelling deck addition, vegetation management. It was issued April 21st, 2016. We extended it for 2 years in 2019 to allow mitigation plantings to establish, and they're requesting a 1-year extension.
So I spoke with Karen Huff, and they actually want to ask for a 2-year extension, which is my recommendation to them. So after the last meeting, I wanted to know, we already asked, they already got 1 extension. What's the reason for another one? And she did put together a letter. I think I forwarded it to you folks today. I send so many emails, sometimes I forget. So sometimes, or essentially the contractor didn't follow through with things. The plants were installed 2 to 3 years ago, but not the temporary irrigation, and then things died, of course. They had to replant, which was only marginally successful. They seemed frustrated as well. Their conditions do read that if another contractor is to do the work, then it has to be approved by us. Given the circumstances, I told Karen that if she wanted to explore that option, that she should do so. And that, because I don't think they seemed as frustrated as, as anything about this. They wanted to reach out to this contractor one more time and give them a chance to kind of rectify things. So given the fact that it's, May and mitigate plantings really can't go in past the end of May because it gets too hot, even with irrigation. I don't think a year is enough for them. And I do want an update from them. I told her at the end of the season with where they're at, but given, I do think they're putting an effort together. I think it's really not on their fault. They want to see this done too. So I would actually recommend a 2-year extension for them with a progress update, say September 1st of this year.
All right, any comments, starting with Ernie? Okay, Stan?
No.
Jim?
That sounds okay to me.
John?
No comments.
All right, Mark?
No remarks.
All right, none from me, so I'll ask for a motion.
I'll move to approve the request for a 2-year extension for 3 Hulse Point Road, map 6, parcel A2-4.
Okay, can I have a second?
I'll second it.
All right, I think Stan snuck it in there first, so seconded by Stan.
I didn't know if his mic was working or not.
It's okay, as long as we get it recorded. So all those in favor say aye, starting with Ernie.
Aye.
Dan?
Aye.
Jim?
Aye.
John?
Aye.
Mark?
Aye.
Myself, Brad Chase, aye. Motion carries 6-0. All right. Well, good to have you back, Amy. Any updates for us? Any new business?
Hopefully hiring a new shorebird monitor this week, which is good because we got birds, a lot of birds. Melissa is officially, our new assistant agent is doing extremely well. If you can attend town meeting this Saturday, it would be, I greatly appreciate it. The weather is looking iffy. They expect to determine whether or not town meeting is going to go forward this Saturday by the end of day tomorrow. So I can definitely send you out an email and let you know if for some reason it's postponed, and the postponement date would be next Saturday. So town meeting starts and it's at 10 a.m. on Saturday. It is at the Monomoy Regional High School in the football field. We are on the docket only for our change to our revolving account, which is our wetlands account for the allowance of in lieu fees. So that's, I'm sure there's more, but that's all I got for you right now.
All right. Anybody else? John, you see any more herring down at Skinnequit?
I have not seen herring. No, I walk past on Uncle Vini's frequently. I did. You got the photo of the snapping turtle, which impressed me anyway. I don't know. I've never.
That's a big one. Yeah, it's kind of a family tradition on Easter. We go catch one and put it in a wheelbarrow and bring it back to the house. And I've never been the one that lifts them. Never picked them up. And there was the legend. You ever hear the legend of Uncle Vini? There was supposedly a 100-pound snapper in the pond.
Jesus.
And people would swear they saw the head of it, and it was, like a football helmet.
I saw Nessie out there the other day myself.
Okay. These rural legends.
I wouldn't go swimming in there, John.
Oh, swim all the time. Come on.
I've seen a 40-pounder, I think. That's big enough. So, all right, anything else? Otherwise, I'll move that we adjourn the evening.
I'll second.
All right, second. All those in favor say aye. Ernie?
Aye.
Dan?
Aye.
Jim?
Aye.
John?
Aye.
Mark?
Aye.
And myself, Brad Chase, aye. Okay, 6-0, we are adjourning. Thank you all. Thank you, Amy.
Good night,
Thank you very
everyone.
much.